10:05, and we will start our board meeting. That is California Architects Board. December's meeting is the last meeting of this year. So with that said, I'd like to ask Secretary to call the roll.
Okay, Tian Feng.
Here.
Greg Gladstone here. Mitra Kanani.
Here.
Sylvia Kwan, not here yet. Evelyn Lewis.
Here.
Robert Kernan, not here yet. Ronald Jones.
Present.
Nielsen Serrano.
Here.
And Sonny Ward here.
Okay, we have a 7-member. Yeah. So we have a quorum and to start our meeting, and I want to recognize attending with us. We have 2 public members. We also have our LATC chair. Is still chair?
Yeah.
Yeah, John Rubinski.
Just reappointed.
Okay. And again, just the procedural remarks. All motions and seconds will be repeated for the record, and votes on all motions will be taken by roll calls. Okay? Before we entertain public comments, a board member wants to say something.
Well, during the past 2-3 months working with the communication team on outreach planning and also some of the items of the agenda that they were working on, I have been in direct communication with them, and more than ever I was exposed to our website, and I'm delighted with what they are doing these days. But amongst all of those items that I was reviewing with them, I realized that our president, Mr. Tian Feng, has achieved a very high recognition. And so, in fact, I was very delighted to see that the announcement, the press release went out, and our president has received the Distinguished President's Medal of Distinguished Service by the National Council of Architecture Registration. So, on behalf of all of us on the board, we would like to appreciate your services. I personally have a great experience with you during my tenure at New School, directing the IPOP program, and how much you were extremely supportive and helpful, and you, in fact, you volunteered to have webinars for students, for shadowing, and for internship. I really appreciate it personally, and on behalf of all of us on the board, I would like to present this new book that I just published on ecological design thinking. Ooh, very
What a surprise. What a surprise. So, thank you so much. Thank you. So by doing so, we just give a few more minutes opportunity for our members coming late to catch up to your agenda items. This is extra. Thank you so much. Okay. Any public comments before we move to next agenda?
Did we do item C?
We are not C. We are on B. I hear now, and we'll. So here now we will move to our agenda item C, and we invited DCA staff Brian Cliff give us an overview of what's the latest of our umbrella department, and with that said, Brian, for yours.
Thank you. Good morning. Thank you for giving me the opportunity to provide the DC update today.
Hey, Bob. My name is Brian Clifford. I'm the Senior Plan Implementation Manager in the DCA Executive Office. We're very excited to announce that the Governor recently appointed another leader to DCA's Board and Bureau Relations team. As we shared before, Melissa Gear is serving as DCA's new Deputy Director of Board and Bureau Relations, and she joined the department on October 3rd. On November 14th, Yvonne Durantis Giles began serving as the new Assistant Deputy Director of Board and Bureau Relations. She previously served as the Senior Emergency Services Coordinator at California Governor's Office of Emergency Services since 2022, and a Policy Analyst and Task Force Coordinator since 2019. She was an Executive Fellow at Cal OES as well from 2018 to 2019. And we're very excited to have this new BBR team in place to serve and assist our boards and bureaus. We are also pleased to announce the appointment of Kathleen Nichols as the Chief of the Division of Investigation. She was sworn in on December 5th. Ms. Nichols has extensive law enforcement experience with over 26 years of investigating and supervisory experience. Her experience will assist in bringing consistency between the units within the division, and we're very excited to welcome her to her new role. Moving on, the Director established the department's first ever Diversity, Equity, Inclusion Steering Committee to guide the department in its equity strategy, initiatives, and action plans. The DEI Committee held its first official kickoff meeting on November 9th and will convene its second meeting in January 2023. The committee will focus on three core areas: workforce, recruiting and retaining diverse talent; workplace, actively educating leadership and staff to increase awareness and create an inclusive culture; and the marketplace, serving consumers, applicants, and licensees with sensitivity to their diverse backgrounds and perspectives. Also, in accordance with Governor Newsom's executive order, strategic plans in effect July 2023 and beyond must be developed and updated to more effectively advance equity and drive outcomes that increase opportunity for all. In response, DCA is revising the strategic planning process to incorporate more inclusive public engagement, data analysis, and embedding diversity, equity, and inclusion into the strategic planning process. Over the coming months, the DEI Committee will inform the strategic planning processes, and by March 2023, DCA will be implementing the revised processes and working with the boards in updating existing strategic plans and developing new strategic plans. Speaking of strategic plans, the department released its 2022-2027 strategic plan on November 2nd. Additionally, with unveiling the new strategic plan, the department also released a new logo. The new plan and logo represent the next chapter and future of the department. Director Kirkmeyer stated, "Consumer protection continues to guide our mission and priorities." Our department holds itself to a high standard in providing outstanding support services, oversight, and innovative solutions to those who regulate California professionals and vocations, so that through this partnership, all Californians are informed, empowered, and protected. The department's strong commitment to diversity, equity, and inclusion, as well as our shared dedication to each and every consumer, is built into the framework of the plan. Next, I'd like to provide an update on the Our Promise campaign. We're excited to take part in the annual Our Promise campaign and celebrate 65 years of caring for California. Board members should have received an email from the DCA Our Promise co-chairs, Chief Deputy Director Christine Lawley and Deputy Director of Board and Bureau Relations Melissa Gear, with information on how to give. The campaign allows Californians to donate to a nonprofit or nonprofits of their choice through December. With your assistance, DCA hopes to continue its tradition of generosity and caring for our communities through this year's campaign. Please assist us in encouraging all members and staff to donate. And if you have any questions, please contact Deputy Director Gear so she can assist. As travel resumes again, it is important to remember that all state travel arrangements must be made through DCA's approved travel agency, Cal Travel Store, or Concur. All board members and staff must use the most economical fares possible when traveling by air on official state business. Typically, this will be the Southwest One Getaway option. However, there may be additional charges if changes are made to the flight. Flight changes to the date and time for personal convenience are not approved without a justified reason, and the traveler may be responsible for any associated charges. If you have any questions, again, please reach out to Board and Bureau Relations. And then just a reminder, as 2022 comes to a close, it's a perfect time to make sure that you've completed all of your required trainings. If you have any questions about what those requirements are and where you stand, feel free to reach out to Board and Bureau Relations. And with that, I'd like to turn it back and answer any questions you may have.
Go ahead.
Yeah.
Doctor.
Yeah, I just have a quick question. The enforcement division of DCA, what do they specifically focus on?
So they would investigate the more serious complaints that are received by the boards and bureaus. So that's really their responsibility, especially if something, say, were also a criminal allegation.
Okay, and that would be in conjunction with the State Attorney General's office, or it's like kind of an intermediary step on that?
The Division of Investigation, I mean, may interact with the Attorney General's office. I would say that's maybe more on the board side, that you guys do a little bit more interaction with the Attorney General. The Division of Investigation conducts those parts of the investigation that need to be done by a sworn peace officer.
Right, thank you.
Yeah, so.
Hi, thank you. Can you tell me on the work that DCA is doing with DEI, is that internal or also includes external work?
I think the approach is both. It's both looking at our staff and our internal processes, but also how do we interact with consumers and applicants and licensees that we serve.
Fabulous. Is there an opportunity for our community to go and speak at the DEI committee event or meeting?
I'm happy to bring that request back.
Thank you. Or if I can give a call or whatever it is.
Yeah.
Okay, thank you.
Any other comment? Okay, seeing none. Thank you very much, Brian, for your information. And you stay here, yeah? In case we have public comment.
Oh,
Take on the floor. Any public comment with regarding the update from GCA. So I hear now. And thank you, Brian. And I will, by the way, today's meeting, I will move agenda around to facilitate our speakers and public members that made the effort showing up here. And so don't surprise that you see the agenda item moving on. So the next one will be Q, that we invited the Division of State Architects to give us an update of the initiative they're working on and the opportunities that they see, it presents between our board and the Division of the State Architects Department. So I will assure you will find this very informative. Some of our regulatory efforts and the director relates to the outcome of some good work that ESA have been doing. So I with great pleasure, I introduce Ida Claire, and she, I believe, is the first state architect who actually promotes the within. She worked for BSA for more than 10 years, growing from the ranks, and she's really earned that position with her professional excellence. And we are very much looking forward to work with her. And with that said, Ida, yes?
Just very briefly, for the record, to note that Member Pearman and Member Kwan.
Oh, that's right.
Thank you, Tian, for the very kind and flattering introduction. So I appreciate that. And thank you for this invitation to be here today. For those of you who don't know, I'll just give a little bit of history about what DSA does. First of all, we do field calls about licensure, and we refer them to you, and we get those often. So beyond that collaboration, I hope to do more. But at DSA, one of our main roles is regulatory compliance for the state's public schools, community colleges, essential services buildings for structural safety, fire, life safety, access compliance. And so basically, in a nutshell, we're the building department for public schools and community colleges. That's one role. And we do regulatory development for that as well for Cal Green sustainability and all aspects of the building code, Part 2, plumbing code, mechanical code. We perform that regulatory development for schools and community colleges in addition to plan check services. We do also do access compliance regulatory development for the state of California, and it applies to all public accommodations, commercial facilities, public buildings, and public housing. And so, and then I think what's important about that is where one of the areas that we can align is the continuing education component. DSA is committed and is required to provide free access training to the state. And we have what we call our DSA Academy, and it is our learning management system that members of the public can take free training, register and take it online on demand. And it also retains the continuing education units and the certificates for you, so it's an online database. And so we've just launched that system within the last couple years. Unfortunately, we've also had challenges in our access compliance department in staffing. We've had quite a few retirements due to situations with the pandemic. I think people just decided they didn't want to be that, deal with work anymore in a pandemic environment. And so we did have a few retirements, and so our offerings have not been extensive online yet, but we are almost staffed up again and hope to continue adding more classes. But we do have one that offers one continuing education unit, and that is through our LMS, and that is the California Electric Vehicle Charging Station Accessibility. And so architects can take that at any time. We also do have life training, which has been going on, and that is the CASP 101. And that is also free for many architects who choose to secure or to pursue certified access specialists. They can take that class as often as they want. That does offer 5 continuing education units, and it's quite comprehensive on the basis of federal law and state law and California Building Code and access compliance. And so it's a class that's quite well received. I think you take it, Leisha? Yeah. And some of others may have as well. And so that does offer 5 units. We offer that 3 times a year live, and that is in an engaging discussion as well. So I think a good nexus for that as we develop increased training for access compliance is when you get requests. If you do get requests on access access training, continuing education, maybe there's a link that we can work with you on your website to provide that, so that the state doesn't necessarily, or the architects in the state, if they need those units in a quick manner, can actually get them. And they can get them from the regulators, the ones that actually write the requirements. Another aspect that we can collaborate is as well the continuing education units that are coming for ZeroNet Energy Design. We do write the requirements for CalGreen for schools, and while it's specific to schools, a lot of our initiatives are collaboratively with Building Standards Commission. The Building Standards Commission writes the CalGreen requirements for the rest of non-residential construction, and so those are often aligned. BSC does not have a training arm specifically. They will take requests for speaking, but they don't have a training arm. We do, and so as I stated on our LMS, so while some of our training for ZeroNet Energy may be directed specifically to schools, it is the same regulations that we co-adopt, and so architects can also facilitate receiving that training to DSA's LMS as we develop it. We have a commitment with AIA California, with BSC, to produce that training as well, and also we would cater that to schools and have it on our LMS. So we are committed to offering those options to the state, to the architects in the state, so that they can meet their 10 continuing education units for renewal at either a low cost, because they're sustainability education. We're not statutorily required to provide that for free, but we do provide it for free to our schools, and so it would be for free to everyone. And then, of course, our access compliance, which we are required to provide free of charge. So there are many options. There are some options that are available now, and as we expand our fair, there will be more options available as we advance. And of course, all our training is accessible because we're required as a state to have it in an accessible format. So there's that assurance as well. I will say that as the access code becomes more complex, state of California takes very seriously its access code requirements and responsibility. We are considered one of the most accessible places on the planet, and we provide that. There's a lot of initiatives in California that address technological advancements, and so we address regulatory activity in a more advanced state than, say, the United States Access Board. So while our minimum requirement is to meet the ADA, we advance and go beyond that to provide that additional clarity. So we have regulations in California for destination elevators that have been in place for 5 or 6 years, requirements for adult changing facilities that the feds don't address. These are all options that the federal requirements don't address. Adult changing facilities are in our access code. Electric vehicle charging stations, which are not also, the feds have recently issued guidance, but it's not regulatory requirements. We have regulatory requirements that have been in place for 5 years. And we also, one of the critical elements is public housing. And we've provided additional clarity in public housing, so we ensure that housing facilities in the state of California that meet the public housing requirements, which means by, for, on behalf of a public entity, or as part of a public entity's program to provide housing, meet the minimum accessibility requirements. And this is a challenge. There's been lawsuits in various cities that they are falling short of this. So the education part and component part of this is really critical for architects. I know that there's a lot of comments from architects that why do we have to take this training? It's the same stuff over and over again. And so I'm here today to say it doesn't have to be the same stuff, that we offer a varied opportunity for varied information that is actually valuable and protects architects in order to make their work compliant. And we also have resources on our website that also provide that information. So collaboratively, if we can work to align our websites, also referrals, discussions would be great, so that we can increase that level of compliance of the architects in the state in meeting their CEU requirements and doing it appropriately. The resources are there. And it's important to address that from the California perspective because we do have advanced requirements. I know that the requirements for continuing education is either state or federal standards, and both are important, absolutely. But a lot of the federal standards training is repetitive and more basic and doesn't cover what California can cover. And so providing that offering would be very valuable to the architects in the state. And while we do our own advertisement for that on our website, because we are the building department for public schools, it's very difficult sometimes to get that out in a general announcement. As you know, people need to subscribe to a state's listserv in order to get we can't just put people on our email, and as you do as well. So it does present that challenge. So that collaborative effort would be, I think, beneficial. So we can talk more. The other thing is when it comes to access compliance, I know that this group is very involved in the whole IPAL integrated path to licensure. I've been in access compliance as an access specialist for well over 12, 13, 14 years, and understand the importance. It was always a priority to me to design with access in mind as opposed to having a compliance check to the code. And I think that a lot of that can begin in our schools of architecture. And so perhaps if there's connections that you have, it's always been something that I wanted to do is to create a module that we can, place into the schools of architecture that perhaps are complementary to a project, just a sectional module that starts to give the basics of understandings of the ADA, the purposes, the spirit in which you design, of a universal design spirit, but also creating that awareness equally to what is being created as sustainability, right, in our schools. Create that same equity component for individuals with disabilities so that our upcoming designers, as they're being trained, have this component, know where the resources are, know where they can get that guidance, know the whys and the spirit in which we can start designing with it. I shouldn't say start, because there's many who do, but I'm saying many of us to be training in the mindset to always consider that as a priority for a design criteria, just like sustainability is a priority for a design criteria. I think they both deal with equity issues, and I think they both need to be complementary to each other. So if there's an opportunity to discuss that, we can develop it, but we'd love to have the ability to really provide that extension into the schools to say, the DSA is here to help you, CAB is here to help you in this, perhaps the IPAL realm, right, to ensure that these architects in training get this training in school to a little bit more of a fundamental level. And then, you know, as they get licensed, they're designing more so, just like with sustainability, with that in mind. A third, I know this is a lot, a third issue is that we know that you also do the supplemental exam, and that if there's accessibility that's addressed in the supplemental exam, and that we are here as a resource for those who write the regulations. We can review your questions. We're very adept at writing exam questions because we write our own exam for certified access specialists. And so we can help bring to ensure accuracy is provided in the exam, in the way the questions are addressed, and in the way they're addressed in the code. We can assist you with that if you know, if that's something that we can help you with. And other than that, it's really just DSA has a collaborative spirit. In our regulatory development, we have extensive task forces and work groups. We find that the collaborative spirit really assists in the regulatory development process, and so we take that collaborative spirit approach to most everything we do. And so I invite that collaborative spirit with CAB in these endeavors that I've just mentioned, and I think together we can really reinforce that the requirements that have been set forth in the legislature for zero net carbon construction and access requirements, that we can enhance it to, instead of being more like a checkbox and I'll just take it and I'll find the free and get it over with, to something that really I think can provide value by directing people and to the right resources. So with that, if there's any questions, I'm here to answer them.
Yeah, well. So this, the board members, this is a regularly scheduled item. It's not public comments. So you are entitled to have a direct dialogue with Ida, and we allocated enough time, and I see tremendous value for having that dialogue. So, but I'd like to save my question and comments for now, and ask our fellow board members have any questions, and after that I will have mine. So thank you, and Robert Salfus.
Thank you, a very good presentation. And not necessarily a question, but just a comment. As we look at our AD requirements and sort of how we might deal with approved providers, the idea of having someone knows that they can be creative for us, not just the same thing over and over again, because you get bored, you see the game, you don't pay attention. But probably they've got an example that they teach it, but they teach in a way that's of interest. So the next time around, it looks different and you're learning something new. So if we can kind of figure out a way to incentivize the providers to do something different and be creative and more interesting, that's a great thing, I think, to have to make sure the requirement takes hold. But same thing with the things we're doing now, we have to under anything new with climate change, et cetera, that kind of make sure we get providers who come up with something a little bit more, something more creative that really is going to be paid attention to as we repeat the course.
Yeah, Sylvia.
I was just curious, how many casts register people are there now?
Yeah, so we have over 1,000 certifications that have been issued, but active CASPs are around 850, close to 850, 900. So our CASPs have been certified since 2008. Obviously, some have passed, some have retired, some have decided it's not really for them, and so they've given it up. But the certification is it's very highly regarded throughout the United States. It's an exam that is extremely regarded. We do have CASPs throughout the country, and we do know now that the Accessibility Professionals Association, which is a national organization, is trying to model a national exam after the CASP exam, which is specific to California, because they realize the value of having that and elevating, for equity purposes, a certification and that resource. And so, yeah, we're about 850, but you know the exam is still pretty rigorous. We just had one, and our passage rates were, you know, in the low 20%. So it's a rigorous exam, and that's why there's 850. But there's a lot of content, and I think it just raises the value that the foundational education that can bring, that sets a mindset in the design. If you understand the spirit of the ADA, you really do become one of those architects that designs in that manner. And I think that that's what a lot of the training that we provide for CASPs, but even for architects, starts to deliver. And so, I think as the younger group has been exposed to access requirements in CASP and the ADA, that tide will elevate for all architects, right? Oftentimes, just like climate change, when we need to learn something later in our careers, it's, I think, sometimes a greater learning curve. And so I think that will start changing, right? Our youth that are up and coming, this is just, if they start learning it now, they really understand it as an exercise of practice.
Yeah, don't be embedded.
Absolutely,
The other
absolutely.
thing I wanted to mention is that I agree with you, that's considered very highly. I believe there are 2 CAS certified people in our firm, 1,400 people, so it's quite precious. And we look at them with great admiration. They were able to pass it. Also, they do put it behind their name.
Mm-hmm.
Like, how proud we are of our FAIAs.
Exactly.
They put CAS behind their initials. Are you a CAS person? Yeah.
No, I am accessibility consultant by an international code council. And this is what I would like to bring up with that when you call international code council for referral or basically for classes for continuing education, they never bring up the
DSA.
And when I took your course, I realized it supersedes all the other ones that I have taken before. And this is something that maybe you want to discuss that with ICC.
I will, thank you.
It's very important that on top of their list, DSA
Thank you, President Jan. And this is a very great presentation. I would say, I just want to make a few observations. I agree that I actually am in the entry level of understanding and pursuing my CAS certification. So I clearly respect the strenuousness of the curriculum. But you said a few things I wanted to point to. One is the idea that accessibility is not just a matter of checking off a box for practitioners. I think that that's a difficult bridge to cross, and how we get there, I think, is a challenge. But one of the things that I think has helped in my assessment is when jurisdictions require it.
Mm-hmm.
There are some jurisdictions that have offices of accessibility, so that helps to advocate for that application. Some cities actually require that you have letters from CAS individuals to demonstrate that they've reviewed your project. So I think things like that makes a big difference. And I'm curious as to whether or not your office and like Calvo have had conversations about working together to get jurisdictions to get this closer.
Yeah, so we do work with Calvo pretty extensively on their access compliance regulatory development. They have an access committee that we work with extensively. When it comes to the requirements of CASPs in the jurisdiction, that's in a section of law that DSA cannot interpret, but we do encourage, because the law is in the civil code, it's directed directly to the jurisdiction. And so how they interpret the requirement to have CASP in their jurisdiction and how they use CASPs really is between them and the city attorney, though we do point out just that there's some issues. And so we try to educate them that the value of having CASPs inside their jurisdiction, which is funded by a permit fee or a business license fee, is very important, and the why, and that they shouldn't just rely on an exterior CASP and a client getting a review. While that has beneficial value, absolutely, because more eyes is great, they shouldn't do it in lieu of doing their statutory responsibility. So we do work with them, and we do have a lot of individuals who are either inspectors or plan reviewers or building officials attending our CASP classes because they have that statutory requirement, and we enforce it in that manner as well, is that the more that we can engage with them and saying, this is why it's important that you have CASPs in your jurisdiction, this is why CASP is important, I think just elevates that further. They start to understand it as well when they take the class and understand the fundamentals of the whys that the federal law sets the foundation of our access code. That it's not just a technical requirement you need to meet to get your permit. It's really in the spirit of inclusivity for, as you will know. But yes, we do engage with them.
Okay?
Yeah, hi.
Hi.
Thank you for coming. I'm a lawyer, but I don't do real estate leases, but it's my understanding that in commercial leases, there must, the landlord or the drafter rather, there must be a statement in there that the prospective tenant has the right to ask for a CAPS study of the premises before a lease goes forward. And as I don't practice in that area, I was wondering if you could remind us if that's part of the civil code of the state, or is that a locality, is that local-based regulation? Because I forget, and maybe you could clarify for us what that law is about.
Sure. And I always want to clarify I'm not an attorney, so especially when I'm speaking to one. So I don't like to give, I can point to where it is and my understanding of it, but I'm not making any kind of legal interpretation, so I always clarify.
I'm not an expert enough to practice.
All right, well, I'm an architect, I'm not an attorney.
Okay.
But yes, it's in the civil code and it's directly to business owners and what the requirement, so the initial requirement when it was first passed was that the lease agreement just needed to state whether or not a CAS report had been performed. And when that was introduced, it was really to start the discussion because many facility owners, when they lease their spaces, do not engage faithfully with a tenant in understanding their status of compliance, which then brings the tenant into liability situation because all access claims, both under state and federal law, is to the property owner and the tenant. And so there have been methods to communicate with the tenant, but the tenant always found obstacles in communicating with their leases with the facility owner and who would be responsible for that. And so subsequent improvements to the law basically stated, I think it's after January 1st, 2017, that and I'm going from memory, but the requirements in the civil code, it applies to a facility owner and it says that you either if you have a CAS report, you need to share it with a prospective tenant. If you don't have a CAS report, the tenant can, prior to signing a lease, have a CAS come on your premises and they can pay for that to get a report. So you have to allow them, and other than that, there's no contractual agreement to allow them, right? But the law says you have to allow a business owner, if they so desire, to hire a CAS to do an inspection. And absence of doing both, it is assumed that anything that is of common use from the facility owner, they bear the responsibility in a legal claim. So it's really reinforcing facility owner responsibility. Of course, while both the tenant and the business owner can get sued, and that's still the case, any lease agreement really should clarify who's responsible for what areas, because if it doesn't, the facility owner actually bears a lot of responsibility in areas for parking, basically to the front entrance door of the business. So those laws are in place. Of course, it's kind of, I've given you an overview, and as an attorney, you would read the technical language, but that is the gist of it, is really placing the responsibility on facility owners instead of passing that on and burdening the tenant inadvertently.
Right. I think that's a really good explanation. I think it's good for people out there to understand that.
And that's one thing we always say. We get business owners who call us all the time. And, I got sued. What do? I need a CAS report. It's important that to get some of the legal protections, or I shouldn't say the legal benefits of a CAS report, you need to do it before a claim is filed. And so we let owners know that. However, any CAS report that you get even after a claim is filed still gives you legal benefits subsequently for any other lawsuit that comes later. But it is in letting them know one of the first things we say is, do you have a lease agreement? Was it executed past January 1st, 2017? Because that's another legal issue, right? That if the owner did not cover these, they need to be aware that the facility owner bears some responsibility here, especially if they've left it out of their lease and didn't address it, that there's a default there. So we do point to it. We're not attorneys, we don't interpret it, but we say, talk to your attorney and make sure they know that this provision exists.
Thank you.
Okay, great. So, Ellen.
I just wanted to make a recommendation. I know you said that we can share information on our websites, but I also think it would be good to share if you guys can make pieces for our comms team and we can share on our social media.
Perfect. Yes, that's a great idea. Thank you.
Yes. So I have comments and observations on a few fronts, and some of those may require staff section, Laura and Karen. So first of all is the resource. We see ESA's education program can be our resource. I just feel bad myself. All these years, I have never taken advantage of the 5-hour continuing education on accessibility from your side. And I don't know how many now. Yeah, there are all kinds of
Today's the
missing
first day.
balls.
Yeah.
You done that. So
How do we get this information out? I never knew about it.
well, we have staff. I think the staff from 2 departments need to talk, and we can easily put all this information by real link on our website.
Yeah, I like that idea.
And social media. And not just the resource, in its quality. We trust you are the source of accessibility and inclusion. And also, we're talking about barriers. We're talking about DEI. Some of the younger architects, some architects that make less money than I do, may prefer is to pay $200 minimum, right, for 5 hours, maybe $300, and they can get a better quality class from you for free.
Free or reduced. Like our CAS 101 is $50 if you want continuing education. If you're registered for the exam, it's for free, and you don't get the certificate, but you can take it as often as you want. But $50 for 5 hours is not a lot.
On-demand is also a very important feature. We spend, I think all of us, take 1 day every 3 years, okay, we justify for it. And we just spend a whole day in a big auditorium and listening to all 5 hours. So, thank you.
I've taken 2 or 3 courses before just because when I finished the first one, it felt so bad. I wouldn't. If I turned this in, this felt bad. I should do it again. Until I'll do a different one. But yeah, this is amazing.
Yeah, that's really we need. Actually, there is some urgencies. I hope in 3 months we make this happen. So our licensees know the resources right there. Okay, I will go check.
Especially with the new requirements.
Yeah, and I do want to clarify that there's many talented professionals out there that provide training. We have some here. So I want to say that. I just want to say that we have a statutory mandate to do so, and just being in partnership in state agencies, our desire is to really grow the on-demand option so that people can take it on demand when they need it. We know there's much more value in an in-person engagement option, so we do like to offer some of that, and a lot of training out there is in person, and it should be for other providers because the engagement is important, but we really want to fill a niche that we can for the on-demand, topic-specific, and so that's where we're looking to expand. So yes, as a partnership, that would be great. I do also want to say that, if we can, since we have your ear in addressing, we do have resources online. We have our advisory manual that for all the California requirements, this is a free download. So you don't have to purchase the code. I mean, you should always purchase the code as architects, but our advisory manual is Chapter 11B, and it contains both federal and California advisories on specific provisions, basically the why. That's available for free. We'd like to let more people know about that. We have a guide to public housing that it considers federal programs and state programs and how to achieve compliance in housing for if you're doing both federal and state, but even just state. So it has a lot of matrices and it assists designers in ensuring they're meeting the requirements because housing is complex when it comes to accessibility. So we have other resources out there that I think is important in addition to our training to ensure that more architects know exist, and that also we take calls and field calls all the time on the access requirements. And so we don't intercede in site-specific interpretations. So if someone says, I have this site and this is the issue, we say, we need you to address your question in terms of a generic question with the code, like, explain to me accessible adult changing facilities, not I have this area and it's right. So because that's the enforcement entity, and we always tell them, if it's site-specific, go to the enforcement entity. We can clarify a requirement, but if you're having an interpretive issue, have the enforcement entity call us. We can speak much more freely with the enforcement entity than we can you.
Yeah.
But we still offer that guidance in the sense of where to point to find certain things that they might be missing that they could look at in the context of the code. So there is additional engagement. I'd love to reach more of our architects out there. They'd have to sign to our listserv, and so that's where I think it's important. Yeah, because you have that ear, right? You have the ear of the body of the architects who also signed your listserv.
Yeah, coming back on the continuing education, the staff need to work with ESA staff to determine the education program they offer meets our regulatory criteria. And if any class is not considered can meet that the 5 hours, we perhaps should put qualify there. But if everything that they offer relates to accessibility can be met and qualified for the 5 hours, it will be great. So I think it's technicalities the staff need to okay?
But, Tim,
Yeah.
all the exams that, all the, I don't know what they're called. Yeah, all the courses that I've taken always stipulate that it meets the California requirement. So as long as they do that, then I take it. And I have confidence that it's going to.
This is an interesting conversation that came up when we were adding the new ZeroNet because we can only regulate architects. We can't regulate the course giver.
Oh, right.
The burden of proof in this most recent round was being sort of, I think we removed it, but it was being thrown to the architect to prove that the course giver was actually fulfilling our requirements. So I'm assuming this conversation is easier because it's interstate department, but there's still a problem with all the other outside providers in that we don't really have a mechanism for overseeing that.
Yeah, the burden is on the licensee to make sure they're taking a course that meets the requirements that we specified, and we don't recommend any. But if, for another state agency, if we can link to theirs, that would be a great resource.
Yes.
That we
It
could
works
work
in this situation because it's interstate.
Yeah, and also because we're the regulatory entity, I think, as well, is in that regard. I will say that to meet your requirements, in our training, we have a list of learning objectives. We have our bios in there because that was also, and so in the presentation, we say, if you need to submit, print this, print your certificate, that's what you submit for your audit, right? And then if they call us, we can confirm that you were there. So we know what the requirements are in the sense of just that they need to demonstrate for an audit, and we are pretty clear that we believe this meets the requirements because we write the regs, but it's really up to CAB to determine it meets the requirements, exactly. So we don't say we meet it, we just say we believe it meets it, this is what you need to prove if you're audited, so.
And of the 800 active cast members that you have,
850 to 900.
Great, that's even better. But does it reflect, does the makeup of that membership reflect those who take your coursework?
So, yes, a lot. And the casts know other highly regarded casts. And so they know who to take the coursework from. And so it's very important that we have a body of individuals who provide that training so that it's not just our burden to do that. And that certification, I think, helps in providing a better quality training. It doesn't ensure, but it helps, definitely. I will say, just so you know, out of the 850, we have about 200 that are architects only.
Wow.
Oh,
yeah.
What Where are the other
That's surprising.
engineers?
They are, so, the statute that developed the Certified Access Specialist Program allows you to qualify via licensure if you're a landscape architect, and we only have 2 of those. So I know that you guys have the technical committee, so around 200 are both architects and landscape architects. But it is a structural engineer, civil engineer, architect, landscape architect qualified $100 per statute for eligibility. The others, it's a $500 eligibility fee because our program is it's supported by those who take the exam. And once you meet eligibility, you never have to pay that $500 again. But it is building officials have to demonstrate, contractors with a contractor's license and experience, provided commercial construction can demonstrate. There's also a category for advocacy for individuals with disabilities who are very well versed in a specific area of accessibility. If they've worked in, say Lighthouse for the Blind or ADA coordinators, they can demonstrate it. So that 850 is a very diverse, yeah.
That's interesting.
And I should say the 200 is California architects. We do have about 20 to 30 casts throughout the country. If they have a California license, they're included in that 200, even though they may not reside, and we do have about 5 or 6 of those. But there are other architects, but they don't have a California architect's license.
Anything from other countries? Maybe that's
Not from other
exciting.
countries yet. Not from other countries yet, yeah.
So I have a challenge for John and Mitra.
Right.
Whoever first gets the house, you will receive a personal award from me.
How about you, Tian?
Occasion like this. Anyway, the second one is technical expertise. So we do California sovereign exams every few years. We review the intent and relevance. And we also handle some issues on regulatory, see if our architects failed to meet their professional stand-up cares. I would call for staff to think about that resource. If you have doubt, you think you need expert opinions on that related issue, I would volunteer DSA to, somewhat provide some light and at least can interpret based on the regulatory aspects. So I think it's a huge benefit. And the last one is the most important one, is longer term. That is education, by the way, is our concern. That's why we meet in schools. We're supposed to meet every hour meeting is supposed to meet at schools, so we are resuming that effort. So this is really the pipeline, and keep the rigor and the competence of California architects for the decades to come. So your effort, look at expanding the understanding of access. It's not just a regulatory requirement imposed on the profession, rather it's an opportunity, it's design aspiration that to produce our architecture solutions, built environment that celebrates use by all, enjoyed by all. So, and for that, I think I want to tell a quick story, and we will end this conversation hopefully. Is Ida is not just talk for talk. She actually contributed to this front. When Mitra asked me, she said, "Tian, you're the public architect. You should do something." Well, she just asked a very nice way of us. That about our students and what is the professional practice aspects as public architect you're concerned most. I just pick one single topic. It's universal design. And that when public serves, architect serves every member of public, the universal design probably is across all concerns. And it's where that we introduce international and the national experts. So Ida actually spent 2 hours almost talking to your students on the universal design from a regulatory perspective. So she's really devoted in these kind of work. So thank you for that. So,
Absolutely, and I'm always, like I said, we have a very big collaborative spirit, and we know that it's that engagement, whether it's with the schools where we try, whether it's with the profession, other state agencies, it just creates a greater understanding of what we all can do to help each other. So thank you for that, Tia.
Thank you. Great. Okay, thank you so much.
Thank you.
for your
Thank you so much.
Thank you.
Looking forward to it. So equally exciting and interesting is next agenda item. Oh, by the way, any public comments relates to Ida's presentation from. Oh, you do. Lucky I asked. Okay, so
I don't need to come back.
proceed.
I need back on.
Yes, sit down. Both of you. Both of you.
I'm Janice Canton, a licensed architect here in California. I'm also FAI, and I am a CAS, one of the first groups of CAS. So that was way back when. One thing I want to say is that the state does not differentiate with ADA between Title II and Title III entities. We have to be very, very careful of that. We need to understand the difference. DSA does deal with schools, which is a Title II entity, but all state buildings, all county buildings, all public buildings are Title II. And it's different parameters under the ADA than it is under the California Building Code. And so one of the things is if an architecture firm is working on Title II entities, then they need to know the difference. And we really, in California, sorry Ida, but we really do not go into that. That is a federal differentiation. So we cannot rely only on the state interpretation. You have to go further than that.
Thank you for the clarification.
It's a clarification.
Where architect can find more information about the Title II and the Title III?
If you go on to the website for DOJ,
Okay.
you can download Title III for implementing regulations and Title II for implementing regulations.
Okay. Can we staff can we?
If you need more information, I'm happy to give that.
So is that a federal designation, 2 and 3?
Yes, Title II is for public entities, Title III is for places of public accommodation, Title I is for employees, and then there is 1 or 2 more titles after that.
But that's federal.
That's a federal designation, yes.
In California?
Well, I'd like to clarify. You're right that the code does not speak directly to Title I, Title II, Title III. We address it in terms of the standards basis, which has requirements for employee areas that are really aligned with with the ABA instead of just the ADA, because that's our responsibility. So we increase those requirements, but we don't say this is a Title I issue. Our public housing is a Title II issue, so we cover public housing because 11A is private housing, but we don't say it's a Title II issue. It's the way I think when we're educating to the ADA, like in our CAS 101 training, we get into that a little bit, but the regulations don't identify Title I, Title II, Title III, and I think that's what Janice is saying, but that's because our model code is the ADA, and the ADA itself, in the standards, doesn't identify the difference. It's the implementing regulations. So we bring the implementing regulations into the fabric of the ADA, but we don't identify it as Title I, Title II, Title III. And I agree with her that in training is fundamentally important. And so we can touch on that, and our CAS touch on those differences. Because the regulations oftentimes in the guidelines and the standards are the same, but the understanding of how they apply to Title II, Title III is an understanding that helps in the design responsibility of whether it's program access or access to goods and services. That's the fundamental difference. Mm-hmm. So yeah, the regulations itself doesn't clarify, but our training does. But yes, it's that's why it's good to take classes from CAS, because they delve into the state and the federal differences on the overarching requirements.
And then one other thing to add, if you're working on anything in this federal money, you're looking at ABA, and you might be looking at UFAS, Section 504. So part of it is where the funding comes from, what kind of program is it, and it's barrier removal is an ADA issue for Title III. Program accessibility There's an ADA issue for Title II. And that gets into transition plans for Title II entities. It's really, really complex, and it's
Very well said, dependent line of work, we do federal work, funded the project, we have to use DOT's interpretation of ADA, which is.
ADA.
Yeah.
DOT will interpret ADA.
And then we also obligate looking into a broader equity perspective, applying Title VI when applicable. So yes, but thank you for your remark, and just to enrich the considerations for architects who want to pursue.
And Tian, I think if I could inject one thing, I think it's also important to understand who is the responsible enforcement agency over those provisions as well. Like the building code basically says that jurisdictions of record are responsible for the enforcement of the Fair Housing Act, for example. Right. So that's not accurate.
That's not accurate. The building departments in California, and years ago I have the letter from the state architect at that time, or the state attorney, I think it was the state attorney
General.
Right, who said that no, building departments are required to implement California Building Code. And DOJ has even come out saying that local building departments are not qualified to implement federal requirements of ADA, FHA, ABA, and all those others. So the onus is on the architect, on the owner, and lawsuits, which is how it's implemented.
Yeah, and that's I guess that's ultimately where I was going with this, is that the absence of that oversight brings the burden back to the design professional to make sure. And even, quite honestly, and even cast members, there's always this disclaimer, even in their reports, that they kind of point back to the jurisdiction of record for interpretation in a lot of these issues, at least some of the reports that we've received. And so part of it ultimately becomes really important that the design professional really wrap their hands around it. As you said, there's so many moving parts, it's extremely complex. And at the end of the day, how do we ensure that in the public's interest that all these things are being properly addressed?
The public needs to be educated.
Yeah, exactly.
And I'll talk to that when it's on a different topic, you know.
These are all recorded, so probably can also log on our meeting them quite a bit. So with that said,
Thank you. I'm Paul Menard, immediate past president of the Central Valley chapter of the American Institute of Architects, and I'm here as a longtime colleague of Ida's, and I've been in public service myself for almost 13 years now. And Ida, I just want to say thank you for the spirit, the knowledge, and the just, dedication that you bring to this job. I think the whole state is really fortunate to have you doing this job. And I know how hard you work. I've run into you at the airport, and you're off to some new series of meetings. So anyway, just to say thank you for everything you do.
Thank you, Paul. I appreciate it.
Okay. Thank you for the wonderful public comments. So we are now entering item N, and it is important, and it's our beloved topic about architects' public presentment and advertising requirement relates to including their license number. And we received additional comment on this regulatory. Staff have reviewed everyone and carefully and also responded to these comments. So my suggestion today is we have on this topic, this is the third time now.
Nice meeting.
Nice meeting.
Nice meeting.
Yeah, nice meeting, but third time we want to take action on it. So I think we want to quickly review the staff's response to few recent public comments, and then we want to take advantage of some public members who will also speak on the topic. And I'd like really make a decision today, ask the board, and I will maybe let the process of propose a motion depending on how the discussion is evolving. So with that said, how about the Karen give a quick overview, and then we invite public comment.
Everyone should be familiar with this item.
Yeah. Anyone need a background? I can provide background. No?
Yes.
Good. Yes?
Yeah, let's just do it real quick though. 1 minute. 1 minute or less.
Well, there has been a push for greater disclosure of the regulation of all of the DCA boards and adding information to public presentments was a way of following that philosophy and that push. And these regulations have resulted in a lot of comments, and the most creative comments I have seen. Architects are absolutely creative humans. I work with medical boards, and they are nowhere as creative and thoughtful and spontaneous of different ways to, what are you trying to accomplish? Here, don't do this, do this. So there are a lot of comments that have come in, and still more. And this board is very responsive to hearing that. And the fact that our original memo from November, or pardon me, of the previous meetings was saying, here are responses to comments, you may move forward. The board can also decide not to move forward. And I do believe we mentioned at this point, you would be having to make a new rulemaking because the notice is going to expire on this rulemaking. So as a practical matter, even if you wish to proceed, it would have to be readopting the text for a new rulemaking.
Hold a second. Yes, that's an overview. Do you want to give some examples of our response to public comment?
And they're all in the packet.
Good.
It's all there, it's all
Good. All right, yeah, great.
Oh, I have a question. I asked for, when this came up before, to report on how many instances there are of disciplinary actions for people who practice architecture without a license. And I know 2 or 3 in today's packet for us to decide. And I believe Laura told me that there was over 150 in the past several years. Do you have can you report on that more specifically?
That's the enforcement folks, and I'm simply regulations on that.
Maybe Laura can.
Yeah, I don't recall offhand, but I can check it out. A lot of what enforcement gets are complaints about unlicensed advertising. So I don't remember offhand the exact percentage of the cases, but a lot of them will be someone advertising. They use the term architect in their advertising or on their LinkedIn posts or professional media, and those are a lot of the type of complaints that we get.
It seems to me there is a problem to be
Yeah.
addressed.
Well, I think I actually chair the RNC committee, our Regulation Enforcement Committee. I was actually surprised, quite honestly, at how benign that sector was. Because what was reported out was that most of the times it's just a matter of informing the person who falsely identifies themselves as architects. They just didn't know.
Yeah,
So-
a lot of them we get, and we don't find evidence of consumer harm yet. It isn't like a consumer brought forward a complaint because the project went wrong. It's that they may, either a licensed architect submits it, someone else, a building official might. So a lot of it is just educational in terms of to let you know in the future you can't advertise this way. And it's sort of like they get a letter of advisement or warning to remind them.
And from my recollection from the report from staff is that then they comply. And so it's not as if there's this malicious intent, at least from the reporting back from staff in terms of the evaluation. So I was actually surprised at how small that number was, because I have to admit that I was an advocate for this measure, with the understanding that serving the public's interest trumped everything else that I was focused on. And so there was a financial burden to me as a practitioner, but the public's interest trumped that burden. But in listening to staff's report, I didn't necessarily walk away thinking that it was that egregious.
I would say that a lot of this is not going to be reflected in our enforcement statistics because a lot of them we close them with what we call a letter of advisement. So staff spend a lot of time going back and forth with these individuals to try to get them into compliance. They will spend months, and we're trying to work that down because it takes a lot of staff time. But that's how we close it, and so that's not going to be reflected in the statistics you see. So probably the amount of time we spend on them is not, reflected in that. But certainly, if we're closing with letter of advisement, we haven't really found any that were worth. Yeah. So it's more of an educational purpose.
Yes, I believe.
I just wanted to call a point of order. Should we have approved
Can you
the
speak up a
minutes-
little bit?
Should we have approved the minutes prior to this topic?
Take it up.
I move around a little bit as I mentioned, and we also after that we will move to closed session. So I did quite a bit of rearrangement to facilitate the minutes. Thank you.
It just feels like you guys had this topic and then we're going back into it without approving what was discussed in the last meeting. So we need to approve it and then continue and approve and then continue the discussion. So just procedures.
There's a, excuse me, there's not a legal requirement to approve minutes on a particular item before the board can take it up again. But I understand the point that that's not a legal requirement.
And by the way, all the outcome of last meeting has significant influence in the discussion here. So, yeah.
I want to go back to the topic at hand. I'd like to remind that most of the comments that we got were from architects and not from public members. And we are here to provide the most transparent procedure for public members such as myself. I want to go hire an architect. I need to know. So I just want to make sure that that's on the record, that making the decisions are for the safety and well-being of the public.
Yeah. Although although the comment is coming in by volunteer base, it's unsolicited. So
Yeah, but if the public doesn't know that they're asking for this, architects or people who are practicing without license are going to be vested in this issue. Someone like me is not going to know that this is out, and we are going to make a decision based that may or may not affect their lives. So we haven't made a conscious effort to say, okay, public, this is what we're doing. So I think that we need to take that into consideration in deciding what we're going to do.
in addition, commenting process, we also had a multiple board meeting, which is all publicly accessible, and the meeting minutes is widely available.
No,
So just
I understand that, but the public, the
technicality.
average Joe does not get access to these meetings. And we have to remember that we are not governing for ourselves. All of you as architects, we are governing for the public. And that's what we have to remember.
Yes.
So, while I don't disagree with what you're saying, I think that when you think about the process that this entails, and the fact that apparently there's no harm that we can prove on a massive scale that this is a problem.
Well, the cases that we have are those that have been caught. We don't know who hasn't been caught, right? So we don't know how big there's no data to weigh that. We don't know. Right? If you don't get caught, it's not a regulation issue.
There is no data to validate either scenarios. So that's fair assessment.
So I'm gonna use fact rather than conjecture to say whether a lot of people didn't report it or they didn't know. I'm looking at the simple complexity, if I may use that juxtaposition, just the complexity of this issue of trying to get architects to put what number. You know, you have to think there are practitioners from 1 to many thousands, tens of thousands. And just the fact of these firms having to decide what number do we put on, do we put in a different number for every single, let's say if you have a multiple number of offices, do you put a different number on every single letterhead? It's really a can of worms that I believe in my heart of hearts, and I've been practicing for 40-some years. I have not ever seen a need for this. The contractor issue, if I may contrast with the general contractor community, because there are so many small contractors that have caused problems. We know that our own very board member has, experienced that personally. That is their issue to deal with. It's not ours to compare. architects are, we're professionally licensed. Everybody has a number, if they have a number, but it is not an easy issue. I'm just thinking really, you guys, of the profession having to deal with this. It is not easy. It is going to be way more complicated than any one of us has ever thought of. And I can just tell you, just based on my own experience, like, who's going to put a number? And then, we have gotten hundreds and hundreds of sort of letters saying, hey, it's going to cost us so much to reprint our cards and reprint our letterhead. That's just the tip of the iceberg. It's really a decision-making process that I'm worried about on how to identify. So anyway, I'm really, really severely against this.
Okay, thank you.
That's right.
Brett and Tom.
First of all, as a public member, I share Neil's point of view, and I think Robert, as another public member, shared my point of view at the last meeting. I think that, with all due respect, Sylvia, the landscape architect's profession has been able to comply, no matter what the complexities are. We do have staff to answer questions and to deal with the complexities. We can have a roll-in period, as I proposed last time, of 5 years, where this rolls over as people licenses renew, and we stay enforcement for that period of time while we educate people. We don't go after them.
I don't think that's in the current language. So.
Yeah, but I'm not proposing. I'm proposing what should be in the current language. I proposed that last time, but I just want to go over some of my proposals to how the language could be changed. First of all, as a lawyer, if my profession decided that we needed to put our numbers, license numbers on all of our material, I would gladly comply. I wouldn't be offended by it at all. And I know some architects find it offensive, but landscape architects are qualified as architects. They haven't found it, to be offensive. And any change is resisted by professions. It's just the way we are. But I had proposed last time some compromise language, and I'd just like to go over that again. And just to remind everyone, as Neil just did, that we're here for the protection of the public, not the profession. And, we've heard from the AIA, which is here to protect the profession, I believe, as much as the public. And that's good to get their input, and the architect's input is valuable, but, our job is to protect the public. And we have heard of many instances in the past anyway, I think that given the architects have health and safety as part of their purview, I think as contractors do, I think that's an important consideration. But my language from last time, I'd just like to repeat it with all due respect, if you don't mind. What I had proposed is first that there be a rolling in period of 5 years, and there not be enforcements. There simply be letters of advisements and nothing more during that period of time. I had also said that what I'm mostly concerned about is the consumer. I'm not concerned about business owners. And consumers, architects have to be licensed if consumers are building over a certain number of units, I believe. And I think that what I'm most concerned about is the media and the social media in particular. And I don't think it's necessary myself to have license numbers on people's business cards. That's all I propose that be taken out. I propose that in solicitations that are to businesses, this not be required either. I'm proposing that people write in professional journals as architects, there not be any posting of license numbers. I'm proposing that on professional stationery, I don't think it's necessary either. But I am concerned about people in advertising, especially social media, which is read by members of the public. Because goes out to so many people, and people who tend to read social media and may get influenced by it are not businesses, but rather consumers. So I'd like to, if we need to develop some language, I'm happy to develop some language that creates exceptions, and hopefully this kind of compromise, will mean something to those of you, who have some objections to this. And I think that's all I have to say. Thank you.
Yeah, Bob.
And I appreciate Bill's and Robert's comment. I think the big piece for me on this issue is who are we, what segment of the consumer are we protecting? From my perspective, the most vulnerable consumer are those who hire architects to do design remodels for their homes, not the consumer who basically rides BART or goes to Kaiser. Those are protected by institutional architects. Consumers who hire architects directly are usually people who are doing work on the houses. I can see that from a personal experience, I hired plumbers, HVAC mechanics to come and repair work at my home. I've never ever gone to the state's website to see if they're licensed. And so the idea that we're relying on consumers to go and check to see if someone's license is authentic or if they're registered, I think is, again, a bridge too far. So it's just not going to happen. I think so. But our responsibility is to build them safeguards and to not say, well, because if people are really concerned, they can just go and look. I would argue that they're not going to look. And so then our responsibility is not to say because they're not going to look, we're not going to require it. It's to just ensure that architects who are licensed provide the information that we think protects the consumer's interest. And so it's sort of this balancing act. And so a lot of the arguments that I've read said that, well, consumers aren't going to look up the names anyway, why does it matter? I would submit that it does matter because our responsibility is to protect the interests of the consumer, not because they may not look, but because if they do look. The only other thing I would say is that we had the same conversation at the REC committee, at the REC meeting, and two things came up. One is that jurisdictions also don't check to see whether or not people who submit drawings to them are licensed. They just don't do it. I know it because it happens all the time. And secondly, we talked about websites. On websites, a website like, for example, House, for example. House basically allows you to post whether or not you're an architect, but House actually verifies that you're an architect in the state that you're licensed in. And so when there are some websites that provide this information, some websites do a much better job at confirming these statements by individuals who suggest that they're architects. Ultimately, the question is, it's really going to be there's a lot of moving parts and it requires a lot of participation, both by the digital community as well as jurisdictions of record, as well as organizations and bodies like this who believe that it's our responsibility in light of all these obstacles is to do what's best in the public interest.
Yeah. Who first? Robert.
Well, first and foremost, at least for the day, as Ms. Howell said, the interest is moot because we don't have time to keep this one alive. So, but I do think that staff wants it in like this, and I think that we should probably direct them to bring it back next year and incorporate some of Brett's ideas in the option. The changes already in the packet, you see they proposed some modifications, staff did already, that try and make it less history of how the landscape runs, we've been subject to it, how we react to that. It might be worth to have staff try to address Rod's point. Maybe they could look at a particular website sample, Yahoo, Google, and go do some and see how many of those people really are unlicensed. So it's not just a complaint. We can say there are 15 names, but 15 were unlicensed. That to me would be a big problem, that percentage. So that might give us some more tangible reasons to do it. Also, the complexity of the architect community. If figuring out who's number to put in the card is too complex, and I should be really scared of the same people designing this building, someone fall down on it. It's kind of a ridiculous argument, in my opinion. And again, as I've always said, give us a different proposal. All we've heard is just complaints about it, and that we should educate people more from AI and others. But they give no substantive counter proposal that we can endure. So that's why I think having it come back next year is still an appropriate thing.
Okay. And Alvin.
I would like to propose that we take an approach, more an advocacy approach, where we can partner with organizations that allow people to promote their businesses and ask them or encourage them to make sure that people have to enter their licenses. The more consumers see it, the more they'll know to ask. In order for us to educate our consumers and knowing how to verify and check and what is available to them, we are going to have these partnerships. And so I yell everything, I look up everything. I want to make sure that anytime I'm doing work, plumbing, or whatever, that I do, and there's a time where I didn't use somebody that was licensed, and that blew up in my face. So for my own educational experiences and learnings, I think that we just need to do what we can. And so I think it's more that people see it, the more that they'll know to ask and be educated.
I also want to, if I could just chime into this, there's many professions that use their license who are used more often, right? An attorney, you're more than likely to use many times in your lifetime. An architect you'll use maybe once or twice in your lifetime. A doctor you use, hopefully not that often, but you use on a regular basis, or you access their services. An architect you use less. The challenge is for the average consumer. I'm not talking about the big institutional consumer, but the average consumer is that we don't even have a website that really shows a photograph that will match their name. We don't have a place where we can actually verify whether the person that is providing the service matches the bid that they're giving you or the proposal that they're giving you. So in terms of the business card argument, well, we shouldn't even be using business cards. It's not environmental. You can just fix it on your, LinkedIn, and that's, takes a few seconds to digitize whatever it is that you need to change. So, there's just the benefits outweigh the challenges, and I like Brett's suggestion that we roll it in, and then people just become the new upcoming architects. They are all digital. They're going to want to do everything digitally. They're not going to have letterhead that is printed. They're going to have letterhead that is digital, and adding a number or two or changing the address is going to be all but, a couple of keys on a keyboard. So that's just my closing comment. Thank you.
Okay. Brad?
Just one more quick comment addressing what Stephen Kwan had to say. Of course, I agree we should, even though we have to bring it back in formally into the regulatory process, I think it's a good idea. I think that to address Sylvia's concern, I think staff should talk a great deal to the landscape architects and see what their experience has been, how they've put it together with the least amount of paying to the professionals, and how they've implemented it, and come back to us with a report on that so that we can perhaps learn from the experience of the landscape architects who have been complying with the regulation that we adopted and we supported, and they supported to add their license numbers. Thank you.
Mr. Chairman,
Yeah.
if I can make a quick comment. In our deliberations about this issue, we agreed that protection of the public was foremost in that. What we really identified as the issue is that for the consuming public, they're becoming more and more reliant on social media in order to find this, and there's no regulation of social media whatsoever. A lot of these sites, even if you want to list yourself as a licensee, there's no way to do that because they just lump everybody's sort of in together. And so for us, we went ahead with this requirement because we felt that it was reasonable, that for the licensed professionals, it's just another level of competency that they can demonstrate to the public. However, we have no control whatsoever about how the consumer seeks out people to deliver services, and to us, that's the issue. The way that we looked at that is that we have a practice act that specifically spells out who's allowed to do what, and so essentially we're relying on the enforcement side of things to punish those that take advantage of the public. And beyond that, there's not really much else that we can do. So that's sort of where things are. It's sort of the buyer beware.
Okay, so again, in interesting interest of the time and also the thoughtfulness of on this regulation, I'd like to make some high-level observations, and I do like to move to a motion and take advantage when public members still here, so we can have a healthy debate. Few things. One is architects as a profession, and in fact, architecture as a profession in general, is building on the foundation of promotes public health, safety, and well-being. Few professions view this as a mission in their entire three elements of their career. Start from education, start from experience, start from licensing. Every of these elements, we are educated, we are taught our mission is provide health, safety, and well-being for the client or public we serve. So we are on the same boat of public protection, very important. We are not a threat to public protection. And two is why we want to even visit that issue of we volunteer ourselves. Say, well, should we consider regulation put our license number on our public presentments? No one asked us to do that. We ourselves volunteer that exercise. So that reflects we are not resistant change. So I think that was not a good characterization that this discussion is because of tendency of resistant change. No, we are innovate ourselves. We impose lots of things on ourselves. We just imposed the 5-hour net zero carbon mandatory education. Architects invented. Architects impose on ourselves. Cause that trouble, if you may. And for what? For the general health and the safety of our people and even planet. So I want to set the discussion in a very positive tone. Okay? And then, yes, when we invented this idea, we tried to solve the problem. Hopefully, we can increase the public protection by put our license number onto it. When we have this idea, it does not mean the idea is very mature, has all the data, all the facts to support that idea immediately become regulations. We did not see that. We have idea, and this democratic process, and we debate, and we will arrive at conclusion, right? So that is how I see it. And at this stage, from all members' viewpoint and from public's viewpoint, I see two things. One is we don't have a real data to prove one way or another, with license number, without license number, actually can improve or harm consumer protection. We do not have the data, right? So, and we are having this opportunity and observe that our sistering profession is just the start of this effort. We don't have data yet from landscape technical committee. Okay. We also have don't have data of medical professions and legal professions publish no license number and how that harm or benefit public. We don't have data either. So I think with all these considered, I just want the member of the board and the public to think the architecture and architects is a positive force for consumer protection. Not just protect people, we're even interested in protect the earth. So I want people to think that high level. And with that said, I would propose a motion that table this regulation. And until we have arrived at such a stage, the data can give us meaningful guidance. And so that will be my motion to my board. And before let me make a motion first, as it is. And then we'll open the discussion within the board members and we'll open to public.
Can I ask for clarification?
Yeah.
So the motion is tabled, it's just
a table.
It's a
Just
table.
table.
I wouldn't add the other.
Okay. Yeah, just table.
I have a question, Rhoda. Does
Point of order. So there's a motion on the floor, and the next question is whether there's a second to the motion. Then we can. Robert, please continue.
Okay, Robert, second.
Can I ask a point of order? Should we hear public comment before?
No, we have motion first and discuss in the other one.
So once this is approved or not approved by this board, it goes to the governor's desk? Is that how the process works?
No, so the regulation, if the board voted to move forward with the regulation, the regulations have to be approved by the department, by agency, and Department of Finance, and then the Office of Administrative Law is the final approving authority.
Okay, thank you.
So I have the motion on the table, to table the motion. that Rob is second. And do we feel we need more discussion before I open to public?
Yeah, I'd like to make one more comment.
Okay.
I'm trying to remember what it was, but I think that we should keep in mind that we are here for the public, and I think we should keep in mind that in no way I think the comments of the public members meant to say that the architect's profession is not public oriented and that it's not pro-consumer. I only am speaking to the bad people in the profession. And I think there's a higher percentage of bad people in the legal profession than in the architecture profession. But nonetheless, you know, and I am a little troubled that lawyers regulate themselves. We have a bar association that regulates ourselves, which is a little troubling to me. But I think we're not intending any of us here to critique the profession. We just have to recognize that there's people who do bad things in every profession. Thank you.
Thank you for the clarification.
If I could make a suggestion, the only thing that I could support the motion, the only thing that I have a concern about is that there's no definitive action. And so if we're going to table it, I think we should table it to a date certain. Table it so that just, I mean, what I can't support is the idea that it dies on the vine. Is that we table it and then it's never addressed again. So my feeling is that we should be decisive either to support the measure. If we're going to table it, we should be tabling it. I mean, I think President Tien basically said until additional data is established, but that should be by date certain.
So like 8 years from now, if I retire, it would be great.
Ron, I agree with you. The problem is the event happened, then we have data. If the event has not happened for 2 years, we don't have meaningful data, so it's harder to put the timeline. That's why.
But to his point, this can be revived with a new. It's dead anyway after today, regardless. Like whether it's voted no against or tabled, the only way it moves forward is if we vote yes, not on your motion, but on the act. So is it a way of everybody being sort of nice and it sort of going away nicely, or like should we vote against it or for it, and then the board can bring it back up. We do the research, you know, and I'm sure I know that staff is because it has been, it's been, I think it started before I even came on the board. It was one of the hardest areas for me to understand when I first came. So I understand Ron's point just a little bit that like maybe that's too nice of a way to end this by tabling it.
We'll certainly do whatever the board wants. I mean, I don't know what else staff can do at this point with it. You know, for elected to ask them to spend more time on it, and the amount of time it takes for this is beyond what my expectations were. And then it could come up in the next strategic planning session. I also, this is going to come up at our next sunset review. It'll be a question we need to answer as to why the board didn't go forward with it. So it is going to be raised again.
I think we should just vote.
I think we should just vote on this.
We have, pass or fail.
But let's hear
that's one motion at a time. So the current motion on the table and the second is table this item. And so now since we have a motion, we can't take it back. We have to vote on this motion first.
Yeah, we can vote on it.
And then we have a new motion. Make sense?
That's correct.
Okay. So
Presuming the motion fails, if the motion, if the motion succeeds, then the item is placed on the table.
I cannot entertain second motion and the vote for second motion first.
What's the number of votes it takes to pass a motion with the number of people here, please?
It's
5.
It's 5.
6.
Oh, 5.
6 today because we don't have 8? Or no, we have 9?
It's 9.
Our full number is 10, isn't it?
It is.
Right. And if all 10 members are present,
Yeah, so we're one
it takes
short, so
6
it's 5.
votes to move an item. If less than 10 are present, it takes 5 votes to move an item. And that's Business and Professions Code section.
Counting voters.
Okay, so because of technicalities restriction, we have to vote on the first motion, and if the first motion or current motion failed, then we will entertain a new motion. Okay, with that said, should we open? We're required to open public comment, right?
Yes.
Okay, we're open to public comment.
Again, I'm Paul Menard. I'm here representing 13 local components plus the state of California component of the American Institute of Architects. Before I get started, I want to say thank you to everyone on this board for your service. It's good work that you're doing, so thank you for that. And I also want to say thank you for adjusting the agenda today to move item up and move this item up. Thank you for that. I was in front of you at the Sacramento meeting in June when this was item N on the agenda, and I'm back today. I have two letters I want to read into the record, and before I do that, I just want to say that our concerns are largely reflected in Member Kwan's comments and Chair Feng's comments. What you both said largely reflect what you're going to hear coming in these two letters. And also, I heard that, and I believe it's true, that we as architects are very professionally concerned with the health, welfare, and safety of the public. And as I look at the young people coming up in this profession right now, they are in it to make a better world. And I really believe that, and I see it every day with the people who are coming up. Okay, two letters. The first one, as I said, is from There's 13 AIA local components plus the state of California component on the letterhead here. And it's addressed to Chair Fang, FAIA. Dear President Fang, the above components of the American Institute of Architects, AIA, respectively ask the California Architects Board not to approve the advancement of the regulatory process, the regulation proposed under Agenda Item M. The growing awareness of CCR 135 among licensed architects has caused significant concern to be expressed about the assumptions made regarding the proposed regulation, the impact it will have on licensed architects, and the presumed benefit to the public. Concerns raised by our members include assumed marketing costs of $100. The initial statement of reasons assumes, quote, licensees needing to update existing marketing materials, that is, business cards, letterhead, contracts, forms, etc., may incur one-time setup printing costs of up to $100. We have been told by our members that these costs will exceed the assumed $100. The cost to design and print new business cards and letterhead and other marketing materials, such as monographs, brochures, and so on, will be significantly higher than $100. Additionally, we assume the business cards of non-licensed staff of architectural firms would have to be redesigned and reprinted, which further drives up the cost per architect assumption. Focus on unlicensed individuals. This proposed regulation was formed during discussions on how to protect consumers from unlicensed individuals. We believe exploring steps to stop the illegal advertising of architectural services by unlicensed individuals should remain the focus of the California Architects Board in protecting consumers from services being offered illegally by unlicensed individuals. CCR 135 attempts to protect consumers from unlicensed individuals by solely placing a new requirement on licensed architects, subject to disciplinary action and fines for failure to follow the proposed advertising regulation. CCR 135 lacks clarity. Licensed architects would be expected to fully comply with the proposed advertising regulation or be subject to disciplinary action and fines. Some forms of advertising clearly fall within the scope of CCR 135, such as business cards and letterhead. Each of these would have to include the name of a licensed architect and a license number. However, there is a lack of clarity of how this applies to other forms of advertisement. For example, would all emails from an architect's work email have to include the architect's license number, or all social media posts about a project have to include a license number? We believe any regulation covering the advertising and marketing of architectural services and how it will be enforced are not fully defined and explained, and therefore should not be adopted. And it could encourage the illegal use of a license number. As we have seen with general contractors, those who illegally offer and provide contractor services routinely use false contractor license numbers, either a number that is randomly generated or one that is stolen from a licensed contractor. Furthermore, by the widespread advertising of license numbers on electronic and printed material, we are concerned that CCR 135 will result in the same with the illegal offering of architectural services. To be clear, we fully support the primary purpose of the California Architects Board to protect consumers. However, we question if CCR 135 will accomplish its anticipated benefit to consumers as expressed in the initial statement of reasons. It is for this reason we ask the California Architects Board to not approve advancement of the regulation proposed under Agenda Item M to the regulatory process. So that's the first letter. This next one is somewhat shorter, and this is from my colleague Laura Nass, who's a principal at Lionakis, a firm headquartered in Sacramento, and Laura was with me at the June meeting. You may remember her. And this one is addressed to Drew Liston. Mr. Liston, our firm of 170 people and 40 licensed architects wishes to once again oppose California Architects Board's advancement to the regulatory process, the regulation proposed under Agenda Item M. The California Architects Board has previously received opposition letters from our firm as well as in-person testimony. Additionally, we are concerned about the exclusive nature of this pivotal board meeting. Excluding the opportunity for a virtual meeting undoubtedly reduces the ability for active participation of the licensed architects in the state. Specifically, the assumed cost of marketing materials is severely underestimated. 2, we believe that regulating licensed professionals does nothing to regulate the unlicensed individuals marketing themselves as architects. Focus should be placed on those unlicensed individuals and stopping their misrepresentation. And 3rd, CCR 135 is difficult to implement and unclear. We are very concerned about representing our firm's 40 licensed architects under a single license number. We have many of our principal architects act as the architects of record on projects. We do not wish their licensed representation to be in conflict with the license that appears on the firm's business collateral and on business cards. It is the individual's license number or the firm representative that is referenced. Architectural licenses are issued to individuals, not firms. A single license should not represent a firm unless you intend to license firms as an entity under a separate licensing mechanism. We agree with the intention to protect consumers from unintentionally hiring unlicensed professionals. We do not believe the proposal will accomplish this goal, but will place undue burden on the licensed professionals of this state. We ask that California Architects Board does not advance Agenda Item M to the regulatory process and that our opposition be read into the record. We appreciate the consideration of the board on this matter. Thank you for your attention. That concludes my comments.
That's, I don't think we can do a directed I, supposed to do directed ILOC. Let's move on to the next public comment.
That would be at the president's discretion.
Okay.
We generally advise that the board not discuss and respond to public comment.
But Robert, when you come back to that, and that's our second item member to speak.
And again, my name is Janice Kent. I'm a licensed architect here in California, nowhere else. I am FAIA, which was awarded to me for my work in accessibility. It was recognized, and I'm a CAS. I have been remotely at most of the meetings this year. I was actually flying up to one of them, got canceled as I was about to step on the plane. But there's several points I wanted to make. And I don't have something that I'm reading like you. These are just notes for myself. We are all concerned about people fraudulently stating they are architects. Architects are concerned, the public is concerned, you as the board are concerned. There's no difference with that. There is concern for that. There's an added concern also that the public does not know the responsibility of what an architect does or provides. I think that's really important because I'm hearing some things even, I don't want to point fingers, but I'm hearing some things in misunderstanding even in this discussion of what an architect is supposed to do and provide. We are licensed similar to CPA, similar to attorneys, similar to doctors. We provide our license number when we give those services. They're individual licenses to the individual, as opposed to a general contractor or any other type of contractor, which is a business license. That's a huge, huge difference. It's my personal license. I earned it. I took the test. I got tortured, and I did it. So it's a personal license. You're comparing to landscape architects. Landscape architects are not architects. They're landscape architects. It is a new profession compared to architecture, which goes back for a very, very long time. And yes, we do deal with buildings falling on your head and other things, and depends what we specialize in. So there is also an additional concern as I said, that businesses and the public do not know that they need a building permit which requires an architect. I think right there, that is the point that we should be addressing. And I'm an architect, you're the board and that kind of stuff, but of all interested people, is that the public does not realize they need a building permit. And that requires, licensed engineer or licensed architect. That's important. If people do not know, and I have an example of that, if people do not know they need an architect, why would they care about a license number on advertising? Whatever that means, because I'm not sure what advertising means. I don't advertise, but I have a website. I write blog articles. I don't consider that advertising. Is that advertising? I don't know what advertising means. People have always come to me. I don't need to go to them. I teach, I do that. Is that advertising? I don't know what advertising means. I don't go and pay for an ad somewhere. That's what that means. People don't know they need an architect. I think that is what's going to protect the public. Let's educate the public. Now, architects have to sign proposals using a license number on it. This is before services are provided. We have to do that. I'm a certified access specialist. I specialize just in accessibility. I'm not doing architecture per se and designing these days. I help with solutions. But I put my CASP number on everything. It's certified. I put my architectural license on everything because that is what the requirement is. Even though I'm not per se practicing architecture, I am an architect. It goes on my reports. It goes on my official letters. That's where it goes. Architects have to stamp their drawings before it gets built. So there's always a double check before a building goes up. So we have to have a written proposal. That's a requirement. My license number goes on there. We have to do drawings for something to get built. My stamp goes on there. I still have my stamp. It still goes on there. It has to be done. Building departments are supposed to make sure that drawings are stamped, whether it's an engineer or whether it's an architect. And I have problems with that, but that's another story. There is also, as you all know, there's also a website already listing architects and a license number. So now we get into, the business, the consumer. And by the way, I just want to correct something. Architects are also consumers. This is to protect us as well as the public. We are the public too. We're part of that group. If someone says they're an architect and does work and they're not an architect, it's hurting me and it's hurting the public, okay? I'm part of the public. Because of this, what I'm just saying, placing a number on a business card or anything like that is meaningless. Because I already put it on my reports. I already put it on my proposals. I stamp my drawings, and all architects do before they put it into the building department. I think if you speak to any licensed architect, we are all agreed that something needs to be done. We're not fighting you guys on this. We think something needs to be done. The question is what? What is going to work? But this feels to me, and this is my own, and I'm also representing CCAI on this, it feels like this kind of let's put our numbers on everything is just to show that we're trying to do something. And I'm saying, I'm from New York. In New York, we tend to be really direct. And I know I offend some Californians with that, but it just feels like we're doing this to show that we're trying to get something done. But it will not actually accomplish anything about protecting the public and the architect, who's also part of this. It won't protect any of us. A story, it's a quick story, and I don't know how much time and stuff, but it's a quick story. I did an evaluation a couple of years ago on public housing. They were going to sell the project. It was existing and probably had about 200 dwelling units. Public housing is a specialty. It's one of my specialties in accessibility. I did the report, gave it to them, never heard them again. Okay, fine, that happens. Some people ask me questions, some people don't. In September, I get a phone call from a new contact at that company. It's a development company. Yes?
I'm so sorry to interrupt. You're welcome to continue, but actually there's a time limitations on public.
I'll talk quick.
Yeah. So continue.
Sorry.
I'll talk New York quick. So, they called me in November, and they said they had a problem. The county has asked them for CAS to sign off, to write a letter that it complies. It's like, okay, I haven't been involved in the project. I need to know what's going on. Did you do the alteration, that stuff? Yes. I said, okay, I need to sign the contract, then I can look at what you have. Well, can you come out and look at the site? No, I need a signed contract. Hey, guess what? I'm an architect. I follow all these requirements. It protects me too. So we finally got in place. She sent me the drawings. 3 sheets of drawings. This is a quote-unquote sophisticated developer. She was someone new working with the company. I didn't see an architecture stamp on it. I looked through the drawings. The first page is gobbledygook that everyone puts on. It was a little less professional than I've seen. Second page was a couple plans which didn't tell me anything. The third page, just forget it. So I go back and I look again. No architecture stamp, and oh, guess what? The company was from Las Vegas. Oh, and guess what? It was a drafting company. And they did this as public housing, a drafting company out of Las Vegas. Okay, so then the next part of it is, I asked them, oh, it looks like they're taking down some walls. Did you have a structural engineer look at this? And they said, I don't think so. They checked. Do you have a building permit? No. So I said, you know, the building is 2-story. There's a bunch of buildings. It could fall on your head. You took down walls. I don't know whether they're structural or not. She said, oh, well, it's only in a 1-story building. I said, great, so the roof can fall on your head. Well, they hired an architect. I said, you're going to need a permit. They're going to need to go in. They spent $400,000 on the alteration, which you could just throw it out. I would love to report this company that does it, but there's no teeth because it's out of state. So now we have a problem. We have the problem where it's educating the public on when they need an architect and what the architect does. It has nothing to do with the stamp. That's the problem. And you know what? I would love to work with here as a group, as a representative of AII, to next year, if we want to put something on the table, to figure out what would work without being a penalization of architects who are doing it legitimately. Now, the only reason why those buildings were caught is because the county wanted a CAS to sign off. And as you heard, only 200 of all the CAS are licensed architects. So I'm looking at this and it's like, would anyone else have caught that? Anyway, that's basically what I wanted to say is we do have a problem. We are agreed on it. I would love to be able to work to help how we do it. And I think it is more about education of the public. What does an architect provide? What do you need? Because if they didn't even go to the building department, they don't even have the building department.
Thank you so much. Any other members sit behind it's associated with this item and coming forward and speak if you are here for this item? Okay, thank you so much for your input.
One
Can we do after you went on with me?
I'm doing one sentence.
Okay, one sentence.
Okay, I specialize in accessibility. Not having an online way of people to attend this meeting does not comply with Title II of the ADA. And you guys are putting all yourself in jeopardy because this is a program of a state entity which needs to provide access. That's what I wanted to say. It has nothing to do with this.
Thank you. And there was not an intent. It's a technical
You tell the attorneys I deal with on accessibility. Yes.
Okay. Thank you so much. And now, just so you know, board will vote on this agenda item, and we will take lunch break. Our lunch break will coincide with our closed sessions to save some time, so our members can fly out on time. So that's the plan. Okay. With that said.
Point of order?
Yes, you may vote on it.
But I would like to know who's leaving early and who may not be here to participate in this continuing discussion.
No one's leaving early, but we need to end the meeting by 4 for members to vote.
Oh, thank you.
Okay. So.
Sylvia's leaving.
So, point of order, we need to call for a vote. We can't
Yeah,
have a
we're
discussion right now about other items other than.
Okay. Mr. Secretary, call for the vote on the motion on the table.
Can you please clarify the motion?
Point where I'm not prepared. I asked to be able to speak after the public spoke, and I'm not prepared to call roll. I didn't think we cut off commissioner discussion.
So we can rediscuss, we can extend additional discussion.
That's within the discretion of the
Yeah,
president.
Okay. I could intend,
Mr. President, if we have a member leaving, we need to go into recess.
okay, before we vote on the motion that our secretary wants to make additional remarks.
Okay, I'll be as quick as I can. First of all, I happen to agree with many of the points of the AIA, which is why in my motion I suggested we throw out some of the ideas in our proposed legislation, such as, letterhead, cards, and other things, and focus more on the internet and social media, and that's where members of our profession are doing all their business, and that's where the consumers are doing their business. So I agree with many portions of that. Second, I wanted to point out that our goal here is protection of the public, and all the public members of this board have wished to vote against this motion, it seems. And I think that's very important. I'm not denigrating the professionals. I'm just pointing out that all of our public members here seem to express concerns with tabling this motion. I'm also concerned about the reputation of the board as in the long term. We have to go through a sunsetting program. As I understand, the purpose of the sunsetting program is to see whether we've accomplished our goals of protecting the public. I think it will look bad that we voted unanimously in favor of this legislation a year ago. Staff has spent more on this legislation than I think any others in the last couple of years. I think we will look bad because we've asked the landscape architects to undertake this, and we're being inconsistent as to ourselves. I think this has long-term implications for our reputation for the public, and before the legislature, we'll be looking into the sunsetting legislation when we come back with wanting to go forward as a commission. I also think staff morale is at issue here. I've heard many times over the past year how much time staff has put into this. I've seen the enormous amount of attention they've given to respond to members of the public. I haven't seen staff change their mind. I'm concerned that if we table this, the staff morale, for all their good intents, will not be into bringing this back anytime soon. And so I'm disturbed that a motion to table will essentially be deemed a motion to disapprove in a polite way. And I think I have problems with that. I think that, as DC has pointed out, to vote against this would be in contravention of a national and state trend for more and more professional commissions to go in the direction of putting information such as numbers on professional licenses. So I want to let you know that I'm going to ask you to vote against this motion, because if you don't, I won't have a chance to make another motion. It will be dead for this agenda and dead for this cycle. And my motion, which I would like to make, but I won't have a chance to make if you vote for this motion, is that we ask staff to come back with new legislation at the earliest time next year to take into account the positions of public members, to create a compromise proposal that gets rid of some of the portions of the proposal that I feel aren't really necessary to protect the consumer. And I've expressed some of those. And thank you for letting me speak. Thank you.
Thank you. It's so important to have all the members have all your voice be heard. Just two clarification. Landscape Architect Technical Committee it was not under the instruction of the board to introduce and pass this regulation. Rather, is the committee themselves initiated and the board provided the support after they adopted at the committee level. Two is the intent of this motion is not to say yes or no. We made it very clear. We to invest in such a critical issue, we need more data that can help guiding us, make sure we invest the public resource reputation, as our secretary mentioned, in a very thoughtful way. So I just want to, when you vote on this motion, be very clear, this is a motion that requires more data, more thoughtfulness, and safeguard our consumer protection system in general. So with that said, now, okay, one more comment.
It's a question, just as a point of clarification. Again, what I saw in my earlier question was whether or not a vote for this motion means that this current agenda item dies on the vine. So so the motion doesn't allow a continuation of this issue. It basically, in all practical matter, kills it all. Kills it because of the time deadline.
The motion does not stipulate, not allow this to continue. I would defer to our counsel to interpret.
In the future, the matter could be taken off the table, but I think correct, and I defer to Ms. Halbo on this, that at the moment, the deadline would already require a resubmittal to the Office of Administrative Law, but that doesn't mean the item can't continue. It would just require another notice. There'd have to be another period of time. It would take that much more time to accomplish the package if that's how that proceeds.
And then the board would need to vote to initiate that rulemaking package one more time, right?
Yeah, you would basically vote on new text that would go out. And
So to clarify again on what Ron's saying, the quickest way forward from this point would be to take up this motion and to accept the table.
Yes.
And it would, for purposes of today and conversation, it doesn't kill this, but it at least allows us to move forward.
Okay.
I would just say, it does kill it, and that this package is not going forward.
That's
The
right.
board could start over in the
That's
future. Staff is not continuing to work
No,
on this.
That's
Sorry, clarification. I thought what we were going to pass right now is to table it or not.
That's right.
Yeah.
Right?
Yes,
And
we're
if
back
we
to
don't
that.
table it, then we bring it back today
No.
and we vote yes or no.
No.
If you're going to table it, we're done.
We're done.
My God, this is just so complicated.
Laura,
It doesn't need to be.
Yeah.
How long does it take you and staff in time and in number of months and in number of hours to restart this regulation from scratch next year?
I don't even know how to estimate that.
You're the one concerned about office morale.
And also, it's not from scratch.
Yeah,
Because
we
we
have a
have
lot
all
of
of this record and all of the
Well, that
public
was my
comments, so
question.
it's not from scratch, but it is a sizable amount of
It's a
time
sizable
to
amount of
try
time.
Yeah.
to start that.
We have a full-time manager that works on regulations, and this would be like the majority of her time.
So why wouldn't we, as an alternative to that, simply, again, I'm not sure what Brett's motion is going to be, but why wouldn't we simply authorize staff to modify the current language? So is it not? So there's no opportunity to modify the current language as it's currently written.
There really isn't, and with it being pending, it just continues the amount of like comments and questions we get, and the staff have to have that dialogue back and forth, so.
Consider the fact this regulation, by the way, is not legislation, has been contemplating with all the experts, internal, external, public input for almost a year.
Longer.
Yeah, 2019.
And I don't think we can have a confidence to say with the last minute comment, we should vote on that motion.
And the reason I'm making that clarification is that Brett was going to suggest that language modification, and what I'm hearing is that you can't do that either.
Unless we vote yes to table it to next meeting.
No.
It would have to appear on a future board meeting agenda, and the board would have to vote to initiate a new rulemaking package. Yes.
Did you know
But
that?
this could be used as-
Motion? You know that?
I defer to staff and council on that. And even in the event the quiet boards vote on resume that regulation, it's a positive thing. It was further validated that time after we have more data that to inform the board to determine further work on this is necessary. So I don't see today's vote impede this future opportunity. So it does that we need a vote at some
Right,
point.
so the vote for the current legislation or regulation is basically a vote for a flawed document. There's really no opportunity beyond today to modify that document.
That's right. Yeah.
And I think that's what is that a fair assessment?
Very, very, very.
I need more clarification. So, Tian, you knew that if we voted no on this and we're gonna table it, that we would not be able to vote on this in the future date?
I knew I needed to defer to staff. I do not know the mechanical.
I don't think it's just Tiana. A lot of us knew at the last meeting we had this exact same vote when we tabled it to today. So and we already knew this. Well,
What was
because
the ask? Like it seems
It's-
like nothing.
it's the
There
same
was a
ask.
motion to table it that did not carry at the last meeting.
That's
And
right.
so Tian indicated in his comments that we would place it on the next agenda, which is why it's here. We're not saying that anymore, so.
So let me give a point of order in terms of the effect of the motion, which would be to a general motion to table under Robert's rules places the item on the table indefinitely. The board at a later time could choose to take the matter off the table. But in terms of this package, the ship has sort of already sailed in that it has reached its conclusion at the Office of Administrative Law. So it would be a matter of making a motion to restart that package, restart that rulemaking, or a different rulemaking as well.
Which, to a point of clarity, we were getting to a point earlier where I said since it's to table it is the same as to vote no.
Correct.
On the action. So I was making a recommendation, although if we don't table it at this point, it sounds like there's other motions that could come up, and so we might be here until next week. So I just think everybody should know that. So at this point, I support the table.
Next,
Call the question.
Mr. President, if that's the rest, if the board has finished the discussion, after such a lengthy board discussion, I would recommend that we open the matter back up for public comment, because some of those, the public may want to address some of the additional discussion. If you're gonna place a time limit, you need to do that as we go on.
I agree with our council's recommendation. We will reopen for public comments, strictly to enforce 2 minutes rule. I will watch my timer. Any public want to make further comments? Okay, thank you.
They spoke their piece.
Okay.
Restate
Mr.
that.
Secretary, yeah.
Want to restate the motion?
Yeah, the motion is to table item M.
Is there a second?
Second.
Oh, there's a second.
I have a point of order, or commissioners or board members allowed to say why they're voting yes or no when they do? No.
No, it's a simple roll call.
Okay. Tian Feng,
Aye.
Rick Gladstone, no. Mitra Kanani,
Yes.
Sylvia Kwan,
Aye.
Ebony Lewis,
Abstain.
Robert Pearman,
Yes.
Ronald Jones,
Yes.
Neil Cicerano,
Abstain.
Sunny Ward.
Yes.
Okay. So,
Motion carries
motion
6-1 with 2 abstentions.
Okay. And someone's voting. Okay. Thank you so much for the public. You come a long way, and I hope you enjoy the nice weather and beautiful campus. Beautiful campus. And she agreed with me. And I really thank you for your sustaining effort to work with us. Wonderful. Thank you for all the board members, such an open-minded and meet the debate. So healthy, it's wonderful. Now we deserve a good lunch. But during the lunch, We are going to make
Close.
every board member work except the staff. So we start our closed session right now, and all the staff can take a break. And
We need to reconvene at 1:30.
we will reconvene at the 1:30.
1 hour.
Yes, absolutely.
So we are ending our recess, and we are reconvening, and we're open to open meeting. We finish our closed session as well. And I'm continuing moving around the agenda items just to again to facilitate the schedule and for other purpose. So the next agenda is we ask Laura to let's do the meeting minutes first.
Oh, that's
Let's
an
do
action
it.
item. Should we do item N, the review of future meeting dates? Yeah.
Okay, do the review of future meeting dates.
So it's in our packet. We have the next LECC meeting, January 27th. They haven't determined if they'll be in person or virtual yet, but we'll let Ron know. He's the liaison. The next board meeting we're proposing for February 24th. We're sticking with Friday, so if members would like to change the date, they can let me know. But so we're proposing February 24th, May 19th, September 8th, and December 1st. The May meeting, I think we picked that date to facilitate hearing the NCARB items before the June NCARB meeting. Locations to be determined. We have the ability to meet via WebEx until June 30th, so we may want to consider exercising that for our February meeting. But we can either determine that today or just, in time for planning purposes. Thank you.
Any comments?
Can we just make sure that our interactive public, software and hardware is working correctly?
So if we meet in person like this, when we choose to meet at a school, this is how the meeting is going to work. We're not going to have the ability to WebEx the meeting and have people participate remotely. So if we want to have that option and meet in person, we need to meet at a DCA facility.
Oh, that's right.
Or like we did, we don't do DCA
We
doesn't
did
have
that in
equipment to do it.
Sacramento.
So we did do it and made it work
Hybrid.
between Sunny's office in West Hollywood and the DCA office, and that actually worked pretty well.
We should consider that.
So that's so if we meet for our next in-person meeting, it would be somewhere in Southern California. So we can look at the city.
No, the reason I'm asking, AIA office, which is in downtown,
Yeah.
that is definitely a location to meet, and there shouldn't be any.
It's just that DCA is the one who provides the ability for us to do the WebEx, and they're not going to offer it at a non-DCA facility. They only have the equipment at DCA. So we could meet at that office. It's just that the traditional in-person meeting like today. So keep in mind.
It's an interesting dilemma because the WebEx meetings are more easily accessible for the public than the in-person the strictly in-person meetings. And the hybrid is a little bit of each, but not as good as each. So it's just something to think about.
I'm sorry. So is it possible, we just having a sidebar here. So when we did the sort of collaborative meeting with Sunny in Southern California, he had the infrastructure.
He had the
to
ability to do it, yeah. In his
And so
office.
is it inconceivable that we just, if we are doing venues, or can we still do the same thing to still choose even educational institutions that have the infrastructure already? Is that?
If they had it, I guess maybe it's possible, but we would need to provide the people to make that work. Because DCA is not going to send the extra staff to
Right, but
do
we
it.
did it for Sunny.
Yeah, but if anything happens, then we also have to discontinue the meeting, I believe.
It was risky.
So it's
It was
a
risky. We didn't know it was going to work.
Got you, okay.
We would have had to.
It happened to work out great,
Yeah.
but it was super risky.
Yeah, just curious.
And I have no technical skills, so I Yeah.
Yeah, thank you.
Okay, well, that was good item, now we.
Okay.
Sounds like everyone's
We're back
ready
to
for the
Yeah,
candidates.
very good.
Okay, great.
So we are going to move to the agenda of election of next year's officers. That is agenda item E. E for election. That's very good. So I would like our nomination committee member, either Mitra or Robert, to present the slate of leadership for next year. My understanding is the slate that we could present is the only slate, but any member feel want to nominate anyone from the floor, this is the time for you to do so. Okay, so with that said, you decide, Mitra or Robert, to present the slate.
All right, well, this will be very brief. We did, the staff list, we solicited nominations from folks. The only names we got were for Sonny Ward as president, Ron Jones as vice president, and Brett Gladstone to continue as secretary. We contacted each of them who expressed an interest in accepting the nomination. They also provided some brief statements to us about how they saw their role coming forward, and they can address those if they wish. But that's the slate we nominate, and of course you can still call Mr. President for nomination as well.
Okay.
May I make a motion to approve the slate?
Yeah, but let me ask, any nomination from the floor? I see none. Any candidate, for now, until we vote the yes, wish to speak to the board? Okay, go ahead.
I would just like to thank our board president for his very long service and congratulate him again, as Mitra did, for this prestigious national award from NCAR, and to express how I think he's been a fair president and has run our meetings well and appreciated it all.
Thank you. Anyone else?
I can read my statement that I sent.
Okay.
So,
Give a speech. I need a big speech.
I said if I was asked to nominate to serve, I'd be honored and willing to take on the role and do so with transparency and integrity. I will actively communicate with the board of any and all responsibilities of the president. And I would continue to work out with our strategic plan with my main focus on diversity and inclusion within the board and profession, with the reminder of our core mission, which is to protect the consumers of the state as it pertains to the work of architects. I'll work very closely with our executive director to continue Tian's unbelievable work with the AIA and other industry organizations, and to ensure that the California Architects Board carries out successfully the work of the board.
Thank you very much. Ron, anything?
Will it be allowed to vote the entire slate in one motion, council, or do we have to do each one individually?
I would recommend doing each one individually. If you want to do the entire slate, I'd ask beforehand if there's any member that objects to that. But I would recommend that you do each one at a time.
So I want to make all three motions. Don't fight with me. So I made motion. We support the nomination committee's slate, and we vote Sonny Wood as the president of the board for 2023.
Second.
And please
call
roll.
Do we have to ask for public comment?
Oh, that's right. We do. Okay. Any public comment?
Okay. All right, I'm going to call the roll. Tian Fei?
Yes.
Brett Gladstone? Yes. Mitra Kanani?
Yes.
Sylvia Kwan?
Yes.
Ebony Lewis?
Yes.
Robert Kerman?
Yes.
Ronald Jones?
Yes.
Neil Cicerano?
Yes.
Sunny Latipo? Sunny? Ward? Abstain?
Abstain.
Now I have to say that.
Yes, okay, yes.
Yes.
Okay, thank you. So unanimously elected Sunny as our next president. So the second motion is the board supports nomination committee's slate. Elect Ron Jones as our vice president
I second.
for year 2023.
I second.
Any comments from members and from public? I also open the public.
Maybe I can read the passage that Sunny wrote for
Oh, that's
in his statement.
Oh.
He said, I would also, may I?
Yeah,
May I?
of course.
Okay.
Can we? Yeah.
I would also very much like to see Ron as president eventually. If the board agrees that he is willing, I'd love to help make that happen. He mentioned to me that he is not ready, but is willing in the future. If I was nominated as president and the board votes for that to happen, I would very much like for him to be VP so that we can get him into board leadership. So.
For those you have not been convinced yourself to vote for Ron, this is something you have to live with. Okay, so yes.
Okay, roll call. Tien Fang,
Double yes.
Greg Gladstone, yes. Mitra Kanani,
Triple yes.
okay. Sylvia Kwan,
Yes.
Ebony Lewis,
Yes.
Robert Kerman,
Yes.
Ronald Jones,
Yes.
Nilsa Serrano,
Yes.
and Sunny Ward.
Yes.
Thank you. Okay, last but not least, the board supports the nomination slate produced by a nominating committee and elect Brett Gladstone as secretary for the board for year 2023. Any second? Second. Any comments from board and from public? Okay, I hear no comment. Let's conduct the vote.
Okay, Tien Fang,
Yes.
Greg Gladstone, I'll vote for myself since Sunny didn't. Ron did. Mitra Kanani, so.
Oh,
Say yes.
I was just
Mitra Kanani,
looking at you too. Yes.
Sylvia Kwan,
Yes.
Ebony Lewis,
Yes.
Robert Kerman,
Yes.
Ronald Jones,
Yes.
Nilsa Serrano,
Yes.
and Sunny Ward.
Yes.
Okay. Motion passed. Welcome, congratulations for you to take on new leadership. Okay, with that said, we are going to introduce Dr. John Barton and to unveil.
Before we, at some point, can we just be clear as a board, our terms and who's rolling off at what point?
Oh, sure.
So I'm pretty sure I'm.
Oh, good, yeah. Is okay? It's not listed agenda item, but.
No, not
But
now,
for the next.
I'll send it in an email and then we can put it on the next agenda.
Okay.
Okay, I think we're moving to agenda item P, is that correct? Presentation on Stanford Architectural Design Program.
Yeah, P, yes.
Sorry.
So,
Okay,
sorry.
should go forward. So should we do the minutes and get some of the voting done?
We don't have.
So we have to. So we have
Budget
to.
update, I have to run.
Yeah, has catch the previous commission. We'll have enough work for the committee. Okay. Thank you for your patience, Dr. John Barton. And you will unveil a program many of us practice architecture for 30 or 40 years, not even know it exists. So this is a great opportunity for us to run. So thank you, and the floor is yours.
All right, thank you all very much for coming. I'm glad we were able to host you today. My name is John Barton. I'm the director of the Architectural Design Program, and I'm just going to walk you through a strategic planning deck that we've been working on. And I'm just going to bang through these slides super fast so that there's time for conversation at the end. A little bit of history, our mission and vision, curriculum, pedagogy. We'll spend most of the time on that. Evidence of impact in our current goals. So we're a young program. We were created in the mid-2000s. There was no architecture program at Stanford before that. There was an architectural track within the urban studies system, and that was picked up by civil and environmental engineering and brought over and turned into a major in 2004. We graduated about 10 to 15 people a year. We peaked in 2018-19, and then the pandemic really hit. But I think the key thing to note is starting in about 2016-17, we became disproportionately women as majors, and we were working very hard to hire folks that work and live and look like them. Our goals are mental and planetary health. They're just the two of the most pressing issues of our time. Both the assistant director and myself live in a dormitory, and we see the students in their non-performative lives. Students perform in the classroom, and we see the mental health issues, which are endemic. We think that sustainability needs to be environmental, social, and emotional. That you can't do one and without the others. So one of our key missions is to become the healthiest architecture program in the country and the healthiest academic program at Stanford. We'll talk about what that means in a few minutes. And to be a visionary leader committed to transforming architectural education, culture, and practice. And we'll talk a little bit more about that as well. So curriculum, we're an unusual program in that we're a 4-year unaccredited program in a school of engineering. Most unaccredited 4-year programs are in the humanities. And so the students get a fair amount of math and science, and then some studio and some graphic skills, some history, some theory, and then they have some choices and the depth options and depth electives. So it's fairly flexible, even though it's we're giving them a lot of engineering, which they might not get in another program. We have a sheet that we constantly update that looks at our criteria, topics we want covered, what courses they're in, and this is a learning document. And we have one for our 4 studio sequence as well. Our pedagogy is based on the notion that architectural education is at a crisis point, and it lacks purpose in its forms and its pedagogy. It promotes toxic competition, conflates academic rigor with stress for all-nighter culture, which is kind of weird, and it sets up a, so we'll talk about, sets up an expectation in the professions as well. It fails to address student wellness and well-being, and all of us who went to architecture school know what I'm talking about. And it lacks adequate future leadership development, civic responsibility, and an architectural meaning. It's disconnected from the issues of our time. This is, it doesn't take much of a Google search to find images like that. And this is tied into the mental health. Nearly half of college students had symptoms of depression and anxiety in the previous year. Half felt overwhelmingly anxious. 75% of struggling students are reluctant to seek help. These are not just architecture students. Suicide is the 3rd leading cause of death in college students. This is Stanford students noting their stresses on campus. They're overbalanced, they're chronically stressed, they're checking boxes rather than developing intellectual skills. They're afraid of failing, and their personal life is excluded from their academic life except in choice points. So we think it's important that we think about well-being, mental health, belonging within the academic learning environment. So Amy and her husband developed the life model at Stanford. And it starts with thinking about the inner life of the student, moves to their relational life, the communal life, academic professional life, and the life of others. And says that all across being familiar with and engaged with all of these things is what leads to a meaningful life. So in the classroom, academics are always the big deal, right? It's the big circle. Traditionally, community is the small circle. And wellness is where you go when you cut yourself at 2 a.m. And we think that's kind of ridiculous. And in fact, it leads to the office having the same problem, where wellness and community are not necessarily part of the professional office. So if they're stacked and siloed, we want them to be equitable, dynamic, and integrated. So the idea is that these three circles grow and develop as the student and the class needs. And we value wellness, we value community in service of academics. And this carries over into the profession as well. So how do we do this? We have course content, process, and reflection. And typically, you see this in a school. You have academics, you have a connection to course content, but we connect to process and reflection within the academics. Community ties in to each of these as well, and wellness ties in to each of these also. Bringing the circles back to the fore. So the life model pedagogy allows students to have a deeper meaning and purpose in their learning, reduces stress and anxiety, increases a sense of connection and belonging, and they're open to taking risks, and failure is allowed. So a couple of things that we do anonymous mid-quarter feedback on all of our courses outside of the university to find out what we're doing, and then we share those with the instructor so that they can take a look at what they're doing and see what changes they might need to make in their course. We also do a progress meeting. We meet as a faculty and we go through every single student, every single architecture course, and talk about how they're functioning, how they're doing in the course. We left the names off, but here's the form for a course. We determine who we need to reach out to. If somebody shows up on multiple courses in trouble, we'll reach out to them and help them be engaged. So what is the evidence of the impact? So we did a survey recently of students. Well, before we get to the survey, we have a near perfect acceptance rate to elite graduate schools. All but one of our students in the last 20 years who's applied to graduate school has gotten into a school of their choice. We've got students right now at MIT, Harvard, Yale, GSD, Columbia, Penn. They're recruited by top architecture firms. Principals in New York firms will call me and say, I need all of your seniors. We think that either they're coming out with a 4-year unaccredited degree with maybe 40 weeks of studio. We don't teach lingo. We teach how to be collaborative, and the firms find these students to be engaged in an idea, able to explain an idea, able to participate and lead. We had one student go to shop. He was made a principal in 16 months with an undergraduate degree. And we also encourage students to pursue other passions. We've had students who come through who decide to be doctors or lawyers, and we work with them in their development as well. We did the survey, as I mentioned, and most work a little bit before going to graduate school. They most worked in an architecture firm. They much worked in other fields as well as architecture. The architecture program, they felt, prepared them for their roles overwhelmingly. It was fundamental of shaping and supporting their paths, again, overwhelmingly. Their well-being mattered, that our attempts were met with success, and they weren't false. They felt like they belonged within the AD program and helped them shape a life of purpose and meaning. So we have a few strategic goals we're working on. Return the program to pre-COVID levels of excellence, community, and student engagement. The pandemic was really hard on architecture schools. It's really hard to teach hand drafting and early design over Zoom. And we lost a year or a year and a half of students who just continually struggle. So we're trying to focus on building back our community, building back our norms for work and effort, and rebuild our community building skills. Provide an architectural and engineering education that optimizes the program's position in CEE, SOE, and SPSS. So we're in the Department of Civil and Environmental Engineering, which is up until this year was a department in the School of Engineering. We're now also a department in the Stanford Dorr School of Sustainability, which just opened up. So we think we can integrate courses. Maybe there's a new track or BA or BS in sustainable architecture within the Dorr School. And we're at the very beginnings of looking at a new track with CS on digital architecture, computer vision, digital twins, and metaverse. We'll see where that goes.
What's Dorr mean, by the way?
John Dorr is the donor.
What's his name?
Oh,
He gave $1.2 billion. And we want to provide an architectural engineering education that optimizes the program. Provide an education which prepares students for work in rapidly changing architecture profession and be admitted to graduate schools of their choice. We want to offer multiple ways through the program and offer robust advising and work with students throughout their careers to be successful and connected to meaning before, during, and after Stanford. I just made a trip to New York and Boston and met with a bunch of our alum just to maintain connection, see how they're doing and what we can do better. Be the healthiest architecture program in the nation and the healthiest program at Stanford. Cultivate a culture in the program that centers these values and ensure wellness, belonging, and anti-racism are centered without sacrificing academic rigor. We're making a presentation to the Vice Provost for Undergraduate Education Leadership Council next month because they're catching wind of what we're doing. And they've got a whole beginning discussion around wellness and student well-being, and we're ahead of the game, and hopefully we'll be able to lead the way for the university. Be a beacon for change in architectural education. Just before the pandemic, I was asked to lead a group of 4-year unaccredited programs at ACSA, Association of Collegiate Schools of Architecture. Hopefully we'll be able to pick that back up again. And model, share, promote this student-centered holistic view of curriculum and pedagogies. Continue to refine what we're doing and to meet the requirements of our student body. Be anti-racist. Host conferences at Stanford and share our models as we develop that. And then we're in the very beginnings of trying to raise $15 million to endow our program. that's a little bit about us. Questions?
So, John, go ahead.
No,
Newton was first, yes.
Hi.
Hi.
I saw the chart, the chart you had about the student body. Can you, do you have one with demographic information, ethnic, demographic?
Yeah, we have. There we go. Underrepresented minorities are the green bar. So we are probably a little bit more diverse than most majors on campus, but not tremendously so. Right now, in the past, we've been better. Did that
Thank you. And I have a follow-up question. How many of your students in your courses are international versus U.S. students? Is there a percentage?
I don't have that right here, but I would guess it's about 20%.
20% international?
Yeah.
Okay, that's okay. Thank you.
Yeah.
Well, first of all, I have studied about your program. I would like to know, within such a rich environment, academic environment, that your program has initiated, the conception comes from environmental engineering. First of all, the question that I have is, you kept talking about well-being. So I was hoping to hear what kind of interdisciplinary attempts the program is doing to establish the foundation of that welfare, or healthy urbanism or healthy environment. So the program that is interdisciplinary within such a rich environment can have a solid mission as to establishing. I would have loved to hear that from you, to see how you are establishing that interdisciplinary path to other disciplines. Also, the other two more. The other one is, I know that Stanford has a very strong neuroscience, School of Neuroscience, because I invited one of your faculty to write a chapter on that. And I know that neuroscience is becoming one of the highlights of interdisciplinary connection to sciences and well-being, mind and well-being. So why that has not happened? That's another question. And lastly, my question is why you have kept it as a 4-year baccalaureate degree that is just letting people go to other disciplines. Why not vice versa? Why you're not establishing also a program, graduate program, to bring from other disciplines into architecture?
Yeah, so I'll answer the last question first. We've talked about developing a graduate program, and we got close before the new president came and shut everything down and did a long-range planning exercise. We're hopeful that potentially in the Door School there'll be an opportunity to develop a graduate program. We have a potential funder who approached me a number of years ago. So it's possible that we would do that. It would be a fundraising exercise of $50 to $100 million. Money at a university, when you have your own money, you get to do what you want to do. When you don't have money, you have to do it the way other people want to do it. So it would be a hard road. We are a 4-year unaccredited program rather than a 5-year bachelor's, partly because Stanford is a 4-year school and they guarantee housing for 4 years. It would be problematic for a 5th year. But we are great believers that students want to study multiple things. And a 5-year program is so structured that you know what you're doing 2 Thursdays from now in 2.5 years. We don't think that's consistent with our goals. And then you had a question, your second question. Oh yeah, and cross-disciplinary. Yeah. So we're always looking for cross-disciplinary approaches. We're always open to new ideas. We did a international studio, when we connected with construction managers and engineers for a number of years. I'm working with folks at TU Dublin on a new potential program of interdisciplinary studies. We're working on it.
Yes, I'm looking at the graph here. There's definitely a trend where over the last 3 or 4 years the program has become much more focused, I guess, on recruitment of women. Is that by intention?
No.
Okay.
We don't recruit. We're open to those students who want to take the program. And I don't know what the reason is. I don't know whether it's word of mouth. I don't know if it's something we're doing. I honestly don't know why it is that way.
Okay, and a follow-up question. Does the program accept students that are coming, say, from a community college and then into the program?
We have one. Stanford doesn't accept a lot of transfers, on the order of 15 a year, because students just don't drop out. There aren't a lot of space for transfers, but we've had a few, and we have one currently in the program.
And do you have reentry students that, say, take time off?
Yes,
especially.
We have had those, Stanford has pretty much, no matter what you do, you can always come back. So we've had students come back after being gone for a long time, working for Cirque du Soleil or working, or they have grade problems or mental health issues, and they come back.
Right, and Ron.
Well, when I went to university, we had a great deal of mental health problems. So I'm really very pleased to see how much you focus on wellness and particularly mental health. First of all, thank you. We probably have the most diverse boards of architectures in the country among them. And so I wanted to ask you about something I saw. It said anti-racism is important, but pro-diversity these days means a lot more than anti-racism. And I'm just wondering why it wasn't more broadly stated, because we have many other protected classes these days, including, of course, more recently transgender people.
That's a fair point. It's not that we're not working on those issues. We are, but we became much more, as a community, much more engaged in questions of racism after the pandemic began and the death of George Floyd. And it became something that was really important to our students and our faculty to focus on. And we have gone out and searched for new instructors who look more like the students. But that doesn't preclude them potentially being transgender or in the LGBT communities. So we're definitely interested in the whole range of diversifying our approach.
Rob, let me first commend you for the program. It sounds exciting. As a architecture graduate student, the rigors of studio in that environment, your graphic with the person sleeping on the drafting table is kind of held on a weekly basis in architecture programs. And so it's the idea that there's a program that's designed to, or at least aspires to, invest in the health and safety of the student, while at the same time providing them with adequate training, is exciting. I'd like, if you could, sort of expound on what does the practical application of that look like? What do you basically pull back on? For example, I would say that most of us who are architects kind of can speak to this, is that the most demoralizing part of the studio environment is the critique itself. And so it's really about standing in the fire line and seeing how much you can endure. So how does that experience look? How does it look different?
Most of us instructors in the architecture program start each class with a check-in. We find out where the students are, how they're doing, whether they're stressed. And that's important as a way of getting to know the students and to normalize the stress so that it can be addressed, not normalize it so that it continues. But it also builds community. If I can say I'm stressed out, or I had a student a number of years ago say that a boy had asked her out and she was super excited. If they can say that at the beginning of the class, then they'll be more comfortable giving and receiving critique on their work. In my courses, I teach in a discussion-based pedagogy. I don't do desk crits. We break into groups, we have a conversation, we do work, break into groups, do work, have a group conversation. So they're working collaboratively. I do that for a couple of reasons. One is I think that we're teaching people how to be designers, and they need to be engaged more directly in their own processes. The desk crit can be a wonderful thing, but it can also be very interrupting of the student's process. And so they don't begin to develop their own process as quickly. We have fewer studio hours. Our studios meet twice a week for 3 hours, rather than 3 times a week for 4 or 5 hours. We have less studio time. A student would typically take about 40 weeks of studio, but they have the ability to be in control of the classroom time. And
Just as a follow-up, you mentioned something about the sort of rolling evaluation during the course of it. And so do you guys discourage sort of all-nighters, which is a common thing?
Absolutely.
And are you guys really monitoring that and creating an environment where it just does it happen? Is it something that you just don't allow to happen?
I don't think we had we had a bunch of studios all with projects due this week. I don't think we had a single student doing it all night. Some of them stayed up pretty late. But the other thing that happens when you discuss a project in every class, students are more engaged in that project and they don't. When I was in graduate school, a project was due on Monday. I started on Sunday, and I stayed up all night, and then I complained about it. So we're training them to engage each other and learn from each other. The other problem with desk crits is it's inefficient. If I go around and talk to 15 students, I'm going to repeat myself 15 times. And the students are going to get one education. If we talk about it, they're going to get 15 educations on that project. They're going to learn how other people learn and develop the depth and meaning in their own learning. Final reviews, we do some traditional final reviews. Most of my courses, they're discussions. We pin up the work on the wall and we talk about it. The students are, when I step back and don't say you should have done this or you should have done that or your line weights aren't good enough, if I don't do that, they talk about their process. And it makes perfect sense. Architecture schools are obsessed with the final product. But the final product isn't what we're there to do. We're there to teach them the process. So if we step back and they talk about the process, they're learning more and they're engaging their colleagues more.
This last question, I'm sorry, this is the last one. Did I hear you say that you live in the dorms?
Yeah.
And I was going to say, was that by choice or by requirement?
By choice.
Interesting.
Yeah. So Stanford has a program called Resident Fellows. My wife and I are Resident Fellows, and my assistant director and her husband are also Resident Fellows. So we hire and manage a staff, in our case of 15 undergraduates who are RAs in the dorm. It's ridiculously fun, punctuated by moments of sheer terror.
So you already answered my question. So other schools, other majors can apply for that program too?
Yes, so Stanford guarantees that you can do any major. There's no applying into a major. There's no chance that you could come to Stanford and not be allowed to take the major. There's a few majors, biomechanical engineering, if you don't have some high school AP, it's going to be tough. But anybody can be an architecture major.
Just curious, do you have to pay the dorm fees or you live for free?
I live for free. I don't pay rent, and I get my food for free. It's a pretty good deal.
And next question is, among all your students, even the students currently studying with you, would you say they are basically go for architectural practice, or they all branch off to different fields, research, teaching, and what was the trend?
The trend is most go to work for architects, and then they go to graduate school, and then we've got a few who are starting their own firms or have moved up the ladder in some other firms. And some branch off and focus. We had one student who works for SOM but as an engineer in New York. We had a student who never intended to be an architecture major. She just loved the community. She's in medical school in New York. They do a wide variety of things.
Thank you. Any other questions? Thank you so much. It's really such a unique program, John. When we briefly met, I did not know how much you've been doing. This is so wonderful.
I do just have one more question. Is it possible to get a copy of your presentation?
Let me check. It might be.
It's on a PDF or something.
Yeah.
That would be really helpful.
Yeah.
Usually we go through staff.
To me.
Right.
Yeah.
Thank you again.
Thank you so much.
Okay.
Thank you for the facility.
Yeah, thank you for hosting
Thank you
us.
for hosting
I
us.
appreciate it.
Any other public members interested in interacting with John, that's your opportunity to. Other than that, we move on to next agenda item, which is D.
We did.
Right?
Minutes.
Public comments, or I
Yeah.
think we've had public comments, so maybe
So
minutes.
any public comments that that is not on the agenda? I hear now.
No, there are.
Yeah.
Did you want me now or?
Yeah.
Oh, that's, yeah, I like
There are,
that. Yeah, okay. So, yes, take this opportunity, Mark.
Thank you. Mr. President, members of the board, Mark Christian, kind of still with the American Institute of Architects, California. I promise you this will be my last meeting I attend. First of all, to Mr. Ward, Mr. Jones, and Mr. Gladstone, congratulations on your elections. We don't get involved in the elections of the officers of the CAB, but we certainly congratulate them, look forward to working with them in their roles. It's been absolutely a privilege and honor to work with the board, the members of the board now, and the past members of the board. And very happy to introduce you to Scott Terrell, that's what I thought, Scott Terrell, the new Director of Government Relations with AI California. He's been on board for 2-3 months now. Comes from the California Legislature, where he is the Legislative Director. He will be the main representative, non-AI member representative of AI California to the board. So if you want to introduce yourself, if anyone has any questions.
Sure, yeah. Scott Terrell here. Like Mark mentioned, most recently worked in the legislature, and I've been lucky enough to have a few months with Mark to soak up all of his institutional knowledge and kind of start building up my base of the profession. In the legislature, I worked for a few members who sat on the BNP committee, so I have some knowledge of how regulated professions work in California, but it's been great to work with Mark to kind of build up that knowledge base. And just want you all to know that I'm here. If you ever need anything, feel free to reach out at any time. I'm happy to help however I can, and I really look forward to working with you all as we move forward.
Thank you. Welcome.
Yeah, thank you.
So just so you know,
Thanks, John.
I have Mark's cell phone number, but I'm not the main cell phone.
You can have it.
By the way, I first met John Barton back in 2003 when he was a candidate for the state assembly. The voters did not choose him in the primary. We tried to help him as much as we could, but politics is tough. And so the state arguably would have been well served if he had been elected, but certainly Stanford has been well served, and the architectural profession, probably even more so with him not being elected and him becoming director of the program here at Stanford. So we've known him for many years now.
Thank you. So thank you again for, and I'm so glad that one young man retired and another young man.
Mark hasn't aged at all. Ever since I've known him.
That's great. Thank you. You're welcome to stay. Yeah. Okay, next agenda item is budget update.
Oh, no, that's the minutes.
The approve of meeting minutes. Anyone has any comments? If not, can someone make a motion to approve? Niels, second, or Niels,
First, but make a second.
Okay, thank you. And do we need to ask for public comments? Any comments from public? No? We can call for the vote.
Okay, Ken Fang.
Yes.
Rick Gladstone, yes. Mitra Kanani.
Yes.
Sylvia Kwan. Captain Ebony Lewis.
Yeah, abstain.
Abstained.
She was not.
Robert Pearman.
Yes.
Ronald Jones.
Yes.
Nilsa Serrano.
Abstain.
Abstained. And Sonny Ward. Yes.
Okay, motion passes 6, right? Do we get 6?
Yes.
Yes, 6, exactly. Good. Okay. Next agenda is now budget update. I just want to give a quick comment that the budget can be a discussion, maybe an important discussion, maybe a year or so, or even longer from today. So I just want to have the executive director give a very high level sentence. When next year at some point we're going to introduce this item for discussion.
Okay.
Go ahead.
Sure. So it's there's a fund condition in your packet on page 25. It is this is really more just a high level presentation. We had a budget presentation at our last meeting, and we thought we would be in need of a statutory fee increase sooner rather than later. But as it turns out, with the proposed fee increase we have going through right now, we're in better shape than we thought. This fund condition shows how we're doing, but the fund condition assumes we spend all our money every year, and it's also not factoring in our fee increase. So we're actually in better shape than it projects here. So I think probably in about a year's time, we'll start looking at our fund condition more deeply, and possibly at that point do a fee study to get ready for a statutory fee increase. But at this point, the board is in pretty good shape. So, are there any questions?
Any questions, comments? We will talk more next year. Okay, I hear now. I also open the public.
I'm sorry, can I ask you a question?
Yes, go ahead.
So is this is looking back?
It's both. So it's got our actual spending for fiscal year 21-22. You can see so we ended with 10.7 months in reserve in the current budget year. So then it's really just projecting forward.
So I guess so all of the initiatives that are coming out of communications and regulations and enforcement, the anticipated cost of those programs and those initiatives are built into this already.
They're just part of, we don't get any new funding, so it's just part of what this
But in terms of how you've allocated it, have resources already been allocated to those initiatives?
Yeah, so we're just going to allocate staff resources as the committees want.
Okay. Any public want to make comment on the site? Okay, I see now. We don't need the action, right?
No
It's for information. Okay. So item H is update about NCOG, and we can have Laura give a very brief highlight as well. Nothing of critical, but
Yeah, actually, nothing of real significance since then. NCRB had a committee summit, which some of the committee members attended. But otherwise, this is just for an update on committee meetings. I'm on the ACM committee, and we met, and we'll make some changes probably to the rolling clock, which impacts candidates. But we'll have more information next year.
Does that mean extending the time?
Uh,
The clock?
Possibly, yeah. We're eliminating the rolling clock. Yeah.
Elimination would be great.
Yeah. It was a long discussion on that.
okay. And so just interesting, they put this discussion on in the context of remove barriers.
Mm-hmm.
And more on the diversity, equity, and inclusion. I thought it's a good approach, and gained quite a bit of support.
Yeah.
And I want to mention that I was also appointed to the committee of DEI, which Nyota is already a current member. So among about 10 or 11 members, 2 of them were from California that speaks something. So just wanted to report to
I'm sorry, can I get what?
the
Diversity, equity, and inclusion.
Oh, diversity. May I ask a question?
Yeah.
I keep receiving from INCOG, because I'm on the committee as well, all of the participants in any kind of INCOG activities to respond to their change of bylaws. I am wondering if Canada has anything to do, any kind of input in that.
Change to their bylaws? Oh, the governance.
The
Governance. Yes.
Yeah,
I'm
so
sorry.
yes,
That's what I mean.
Good question.
The committee of DEI had made significant contributions starting from Nyota's year, which is 3 years ago, and now I recently joined. It is basically, again, in the context of promote DEI. So
We can put it on the next board agenda. They have like listening sessions right now. They had the second one yesterday, and they have another one next week. I think it's a little bit like completely developed. It would be good to bring it for board discussion. So it's a good point. But yeah, so they're looking for input right now.
So
with a possible proposal would be at the June annual business meeting, right?
Invitation to the old members. I saw Ron, you logged on. At least
Yes, anyone can participate in the sessions.
I've been in 2.
2. Yeah.
Maybe my question was, I don't know if you know, that if this question has been raised to boards, like California Active Board or any board around the country.
if any of the boards have discussed it at their meetings yet. I don't know. I can check. I can check with other executive officers and see if they've taken a position or just if they've discussed it.
Discuss it and take a position on it.
I will follow up.
Okay. Any other comments before we turn? Okay, we open up for public comment period. Is there any comments? I see now. We move to next agenda, which is update of our committees at CAP. And Laura will do that as well. And that's agenda item I.
Yeah, we have oh yeah. We have 3 LEC items. Actually, John, do you want to give the update or do you want me to?
Why don't you go ahead and I'll
Okay.
answer any questions.
All right. So the first item is it's up for discussion, possible action on proposed regulatory language for emergency rulemaking. This is in response to the fact that CLARB, which is the Council of Landscape Architectural Registration Boards, is changing the format and the version of their exam, so similar to the ARE. Theirs is the LARE, and they're changing it, and it's going to restructure. It's going to have different divisions, but we currently have 4 divisions. So in response to that change, LATC needs to modify its regulations because it impacts California candidates. Currently, candidates can take sections 1 and 2 in California before they gain their experience. But they're changing the divisions, and there's not going to be an equivalent 1 and 2 that would match up with their regulations. So LATC and actually the board had already voted on emergency regulations to try to address this and help those candidates. But I can maybe turn over to or just mention that legal has doesn't think we have justification for emergency rulemaking on that basis. So that LATC at its meeting in January is going to hear this item and consider additional actions to possibly take to address the situation. So this is really now just to bring it to the board's attention. We don't need action on this item at this time.
And if I can just add what the issue is that we have approximately 200 candidates that have either already taken and passed Section 1, but they're ineligible at this time for Section 4. So when the test transitions, unless they pass 4 between now and December of 23, they won't get credit for Section 1. They'll just have to take the whole thing over again, basically. And we've discussed this issue with CLARB, and they've refused to budge at all on that. So that's why we were looking at this emergency measure, which was to basically waive the 2-year experience credits only for those candidates so that they could take Section 4. And unfortunately, we were told that we don't meet the criteria for an emergency, so we're going to have to kind of go back to square one and figure out how to address this.
And the LARE is different from the ARE in that it's only administered twice a year?
3 times.
3 times a year, whereas the ARE is continuous. So candidates have fewer options to try to complete it before the 2 years. I'm sorry?
Every 60 days.
For the ARE? Oh, waiting period, yes, but it is offered, you can schedule anytime.
So this item need.
So no action, it's just an update.
No,
It previously would have been before yesterday, but now it's
Okay.
not, so it's
No action.
in process.
So you can move to sub-item 2.
Yes.
Okay.
This is an ongoing item of the disciplinary guidelines. Can I ask you this?
Yeah, and this is it. This is going to be the end of it. That we submitted.
Oh, sorry. Can I group? Council, can I group these agenda item I's public comment into one? We have sub-bullet.
If we're gonna take action, then take public comment on the motion, and then probably at the end of the item, we should take public comment on the entire item.
Okay. So let's skip. We don't have a motion, so we go to sub-item 2. Karen, sorry about
Okay, the disciplinary guidelines were submitted to the Office of Administrative Law, and they reviewed through all of it and had questions. I believe we get a memo on this. It's where their questions were. We worked on drafting modified text. We withdrew because they have 30 days to either up or down, and you withdraw if you can fix it. And we circulated, LATC circulated the modification of text. There were no comments, and so now we wish to resubmit the package and pretty much have gotten agreement with the Office of Administrative Law that that's why we negotiated what to say exactly, that this can get passed. But we need the board, and the committee adopted that language, and we need the board to adopt the modified language of the disciplinary guidelines. What did we have here? Yeah, just that we have modified the language and
For whoever's interested in making a motion, the board is asked to consider a motion to approve and adopt the proposed modified text to amend 16 CCR section 2680. And as there were no adverse comments received during the 15-day public comment period, delegate to the executive officer the authority to make any technical or non-substantive changes that may be required in completing the rulemaking file and adopt the proposed second modified text as noted.
Just a point of clarification, this is recommended by staff and by Karen and by, I'll make that motion.
Good.
Second.
Okay. Any comment from public? Okay. Secretary, I think we can comment.
Okay, Tien Feng,
Yes.
Rick Gladstone, yes. Dietrich Nani,
Yes.
Sylvia Kwan, absent Ebony Lewis,
Yes.
Robert Kerman,
Yes.
Ronald Jones,
Yes.
Lisa Serrano,
Yes.
and Sunny Ward.
Yes.
Okay. Motion passes.
Okay, so the third item, LATC.
Excuse me, who seconded it?
Nielsen.
Thank you.
So LATC is at the cap for their fees, so which means that they're charging as much as the statute allows them to do so, and they're in maybe a more precarious situation than the board is at this point with their fund condition. So they're looking to have a statutory fee increase, and so in order to go to the legislature to ask for money, the legislature wants you to perform what's called like a fee audit or fee study to determine how much it costs to do the work that the statute requires you to do, and then see what you should charge to pay for that work. And so DCA, the budget office, was kind enough to do that study for us. It was kind of the first time they did it rather than having us contract out, which was great because it saved us about $25,000. But so we have the fee study in the packet. LATC talked about this extensively at the November meeting and really had a good discussion and really tried to balance, the concerns about the impact on the profession with the proposed fees. And I can maybe turn it over to John if he wants to say, but we have the information in the packet as to what is being proposed and what LATC is recommending.
Yeah, we found out, I guess, roughly 6-8 months ago that our fee, or I should say our budget was in a very precarious thing. The way it looks right now is we're going to actually be in an actual deficit next fiscal year. And so we had to act on this really quickly in order to prevent that from happening. And as Lauren mentioned, we had a really lengthy discussion on this in regards to what we thought was realistic as far as a new fee structure. We did not want to increase the fees to the point where it became prohibitive for people wanting to actually apply for licensure because it was just, the costs were prohibitive. And we came up with what we feel is a reasonable fee structure, partly based on what the record shows it's actually costing the staff to process these particular items, but also to allow enough cushion that over the next 8 to 10 years we should be good and not have to come back and revisit this. We also decided that we really need to push just to encourage more people to get licensed because ultimately that's what's really going to keep us going. And so with that, we're asking the board to approve this. We think it's reasonable, and it's always difficult to ask people to pay more, but realistically speaking, we have not increased our fees maybe for the last 10 years or something like that. So
this time.
I would feel comfortable.
So
Yeah,
moved.
go ahead. Yeah,
So
go
moved.
ahead. I second.
I think we need a motion.
Oh, I'm
We're
just gonna
saving
read the
motion.
motion?
Yes.
The board is asked to review the proposed LEDC fee schedule and recommend to the legislature that the statutory fee caps under Business Professions Code section 5681, schedule of fees be raised.
So move what she said.
And I second.
I second it, but I can
fight it.
I can give it to you. Okay, Fred second.
All right.
Any, no more public comment. Yes, public comment, anything? Good.
I have a question, just as a general comment question to John. It appears as though landscape architecture is challenged by non-licensed individuals, much like architecture is. It's not uncommon for landscape contractors to provide landscape design. How have you guys looked at how you kind of navigate that space? Because there's no incentive to be a licensed landscape architect if you can practice in principle without any consequence. So how have you guys managed, or is there a conversation about that at all?
Yeah, there is, and it basically comes down to, especially individuals that are working within firms, that there might be specific individuals that are stamping the drawings. So if you're not required to do that, there's sort of not an incentive to want to go ahead and get licensed. We personally feel that it's important that everybody should be licensed for a number of different reasons. And it is a dilemma. We, especially in the residential design market, it's really difficult to get the public to understand the importance of working with someone who's demonstrated that they're actually professionally competent to do the work. So it's just an ongoing, dilemma that we'll just have to continue dealing with.
But much like we're trying to manage it on our side, there's no effort on your side to regulate and manage and to go after those people who are. And again, is there any, where are the concerns about the representation? Yes, is this out of order, Michael?
That's where I was about to go.
No,
Yeah.
Okay.
Then this matter really isn't on the agenda. It's the fee schedule.
I can ask this at their committee.
Absolutely.
I'll do it.
Yeah, I would just say that part of the reason.
We need a detailed discussion on the item because we're off the agenda. My apologies.
Well, this is directly related to the reason why we asked for the fee increase, and it has to do with the number of licensees. Landscape architects in California compared to the Architects Board, we have a much smaller cohort, and so we're limited to the amount of fees we're able to bring in, and unfortunately, with business modernization and a number of other things, we're just not able to keep up with that. And that's why we're facing this much more quickly than the Architects Board is and a number of the other boards.
The cost is right amongst a smaller population.
Right.
So I ask again in case public now want to comment. If not, we're ready for roll. Oh, no, for vote.
Okay, Ken Fang.
Yes.
Rick Gladstone, yes. Mitra Kanani.
Yes.
Sylvia Kwan is gone. Bethany Lewis.
Yes.
Robert Pearman.
Yes.
Ronald Jones.
Yes.
Neil Zistron.
Yes.
And Sunny Ward.
Yes. So, thank you. Motion passed. We now have agenda item B. That actually is, the skip is regulation and enforcement committee and other committees as well.
Just REC, that was the only one that met.
Okay. So, between Ron or Laura, which one you want to do this item?
Oh. Would think. But REC met in November and they are making additional progress on their strategic objectives. In the agenda is in the packet. Bear with me. Let me just pull it. It is on 84. Yeah. So we did talk. So the committee talked a little bit about more detail on enforcement cases, but I think they spent more time on talking about educating practitioners on the standard of practice during the renewal process, and that's something continuing to work on. I think both the board and RC have talked about educating the public and practitioners about the roles when contracts are signed with a third party, and that's an issue that we've seen with some enforcement cases. So I think that's really just an ongoing discussion. And then I think we'll work with the communications committee on developing written narratives, and case studies of common violations to provide better education to consumers. And then again, talking about monitoring social media to proactively enforce against unlicensed advertising. That I think always continues to be a challenge, and kind of the best way to go about that. So there weren't any action items. One of the enforcement analysts did give a presentation on kind of how the enforcement process works, which I thought was helpful, and I think we'll have him present it to the board at the February meeting to give a better overview of enforcement and how we handle it at the board. But he wanted to make some changes before we did that, so it'll be the next meeting.
And I think that the one heavy item that we talked about is really, and I think Laura alluded to, sort of the third-party relationship between design builders, architects, and developers, and where does the end user fit into that equation? And so I think that we don't necessarily know the answer to that, because I think that we recognize that it's really, really complex. Not only we've talked about it at the residential level, but at the commercial level, oftentimes architects are working for design build companies, and who are they contracted with? The people who occupy the building, or the people who the design builder, or the building owner. And so that's where the dilemma comes into play, is that the relationship is not with the building owner, but is with the contractor. And where does the owner, the architect's responsibility stops in terms of liability and our responsibility to serve public interest.
Thank you. So just want to remind the board, this is one of the items in our strategic plan, and the board wishes to be more informed about the rule and regulations, common practice of fines and how do you call them? Citations, all that. So thank you for the committee. Today there's one comment on that subject in terms of amount of fee is assessed. If you have another meeting, can you look into that and inform the
We did talk a bit about that, about whether the fine amounts were appropriate, and I think the discussion was that we wouldn't seek to adjust them because, we don't always go to the maximum, they sort of balance out, and we have the ability to assess multiple counts of citation for most egregious cases, so the fine can go over the amount.
And I think, Laura, you were suggesting that we present those
Yes.
findings at February.
Right, yeah, so the board will get more information and see if it wants to do anything with
So, Ebony, this is designed for you.
Yeah. Nice.
Okay. Any public comments from our audience? No. Okay. We are moving to the next agenda item. That is J and Executive Officer's report. That will be going through very briefly.
Okay, I'll skip the reading of all 16 pages and just get the highlights.
Okay. Just 6 pages.
Yeah. Business modernization is moving along. It is going forward. It is costing an awful lot of money, but we expect the first release to be in February. It's called minimum viable product. So the first phase of it will be available to licensees in February. So it's going forward. Staff is doing a great job working on this. It's taking a lot of time to get it on board. Onto the next page, we have information about updates on personnel or social media. We have a new person in our office assigned to social media, and she's been doing a lot of posting, which has been great. And then we have updates on our regulatory proposals, which I think we want to talk about later on. We already talked about that. We're continuing work on the zero net carbon proposal that the board's already approved. And then on to page 6, we have the LEDC regulations, and they continue to be very effective and efficient in their regulatory proposals. On page 8, we have statistics on licensing exams. You can see our CSE pass rate was 76% for first-time test takers, which is great. And then on page 9, we have the ARE pass rates in the comparison between the national pass rate in California. Construction evaluation and project management continue to be the two divisions where California candidates perform less well than national candidates. nicest way to say that. And then on page 10, we have the similar statistics for the LARE. You can also see that they have the same issue the board does in terms of California candidates versus national candidates and the pass rates. And then moving on to page 11, information on our citations and complaints. I just want to note that the first column and the third column are the same, so we should have changed this, but it's because it was the first quarter and that's the fiscal year. But to note, the average days to close for the current year was 392, which is significantly more than the prior quarter. And we closed a couple of really old cases, including one that had been pending at the division investigation for a couple of years. A few of them that went through the formal discipline, which takes a few years to conclude, so that's why it spiked up, and I would expect it to go back to normal with the next reporting period. And then on page 12, you can see the numbers of complaints, and then the administrative actions citations that we took since the last reporting period, and then the landscape architect was on page 15, going on page 16. The landscape architect citations are at the end there on page 15 and 16. Are there any questions?
Quick one. Does landscape architecture license involve the California supplemental exam as well?
They have their own California supplemental exam.
Just a question. And then a comment. So this year, AIA's Monterey Design Conference has offered many lectures, was designed to meet the requirement for the attendees meet the requirement of net zero carbon design, which will take effect next year. So I just asked staff looking to carefully, I think they meet our criteria, and if you think staff thinks so, we should honor these credits they took.
They can contact us as they were planning and ask for information, you know, and all I can't make a guarantee.
Yeah, of course.
They are familiar with what the requirements are supposed to be, and
Yeah.
they're good at providing continuing education and
So we don't. It's all without charge, all free to every architect in California, wherever those courses are available without charge.
Okay.
Question? Has there been any discernible change in the categories of alleged violations that we see in the last year or so and before?
no, they stay pretty consistent.
Continuing education.
Oh, no, you mean just like in
general. Okay.
So I guess the only question from an administrative standpoint, does that mean we're reflecting reality, or that's just the way our analysis gets to us? Maybe in a few years, this year, I take a hard look at that to see if
they change.
that pattern.
Yeah, and
is
that's a
the
good
real
question,
world,
because
is that pattern just the way our enforcement mechanism works?
Well, and I think that our objective, I suspect, should be to see that number go down. Because if we're doing good work, meaning both in education, both the consumer and the practitioner, then there should be less infractions, unless we just hit that place where it's always going to be that. But I think that's where I start to say, if we're making an impact, I think one of the public comments before was that doing work just for the sake of doing work shouldn't be our goal. We should basically be doing work to basically see results. And so from my perspective, we should be targeting some reaction to our efforts.
Okay, and actually, Robert, usually we have a chart in here with the most common violations, and we don't have it in here, so we'll put it in the next time, but also spend, not just duplicate the chart we've had, but really make sure we take the time to look into it and see, maybe compare it with like the last
It'd be
5
nice
years.
to have the data.
Yeah, that's a good question.
Right. Any public wish to make comments on this item? Okay. We are moving to item K, that is about regulations about retired license application. Board has approved a long time ago. I think staff just want to make some non-substantial whatever changes or something.
Very nicely explained.
Yeah.
Yeah, well, it's not non-substantial, but it is something that the board wants, and it's a question of strategy. Do you turn it in, negotiate with OAL, and then do the 15-day, or if we want to get these as soon as possible, because you have retirees who have been demanding it over several years, and I'm very aware of that, it was like, let's modify the text, and you have that in your packet, it's yellow highlighted, just making very clear that if someone who has retired and is trying to return to practice, they comply with these particular things, but they don't have to go and get a brand new degree. They don't have to go back to the education requirements. And while the initially drafted language we thought made sense. A senior attorney said, you know what, OAL is being very, very picky, and you'd be better off getting this clear by putting this in. So this was circulated, there were no comments, and basically we are asking for a motion to adopt the modified text, so with that basically
One line change.
clarifying, one line change, yeah, like I think we're at 8 words. And once you do that, we have pre-approved the whole package, and boom, we can get it into OAL right away.
So for anyone who's so inclined, the board is asked to consider the proposed modified text, which was circulated from October 5th, 2022 to October 25th, 2022, and received 2 public comments in support. Entertain a motion to approve and adopt the rulemaking text as modified. Direct staff to take all necessary steps to complete the rulemaking process. Delegate to the executive officer the authority to make any technical or non-substantive changes to the proposed regulations that may be required in completing the rulemaking file and adopt the proposed regulatory changes.
I make the motion.
A second.
You're the second.
Ebony.
Evelyn, good, thank you, Evelyn. Other comment?
Thank you, Mr. President. Members, Mark Christian with the American Institute of Architects, California, on behalf of our older members who look forward to being able to get this retired license. Once again, we fully support this. Thank you.
Thank you, Mark.
It's a long time.
Okay, so we have a comment and we're ready to vote.
Okay, so roll call. Tian Feng,
Yes.
Rick Gladstone, yes. Mitra Kanani,
Yes.
Sylvia Kwan, absent. Ebony Lewis,
Yes.
Robert Turner,
Yes.
Ronald Jones,
Yes.
Musa Serrano,
Yes.
Sunny Ward.
Yes.
So our last item.
Go ahead.
Oh, agenda item L, one more regulation. This has a handout which I emailed to members, but I provided a copy for you, and I'll let Karen take it away.
Again, this is the fee package, and I'm communicating with Kimberly, who was drafting up this. It was like, okay, you just got a few comments, we just need to address those comments. But the handout gives you each comment. They were provided in your packet, so you review, because it's an obligation of the board to review all the comments, and then expressly say, on this basis, this is why the board is not making a change. So approval of the comments and a motion to instruct the executive officer to finish the rulemaking process, and we will do so.
For whoever would like to, the board is asked, upon reviewing and considering the public comments received during the 45-day public comment period, and during the public hearing, to adopt the proposed response to the written comments. Direct staff to take all steps necessary to complete the rulemaking process. Delegate to the executive officer the authority to make any technical or non-substantive changes to the proposed regulations that may be required in completing the rulemaking file, and adopt the proposed regulatory changes.
So,
Second.
I second. Oh, good. I agree with you. Neil so moved, and Robert second. Any comments from public?
Very quickly, thank you, Mr. President. Members, Mark Christian, American AI California. We have no position on this, but we always support the board having the funds necessary to carry out its mission of protecting the public. I believe the ceiling right now, the statutory ceiling is $400. It was raised many years ago from $200 to $400 with legislation jointly sponsored by AI California and the CAB. We never want to advocate for higher fees on our members, but we fully support the board having the means to carry out its duties.
Thank you. Okay, with that said, we can take the roll.
Tian Feng,
Yes.
Rick Gladstone, yes. Mitra Kanani,
yes.
Sylvia Kwan, absent. Ebony Lewis,
Yes.
Robert Turner,
Aye.
Ronald Jones,
Yes.
Musa Serrano,
Yes.
and Charles Ward.
Yes.
So I want to give a big speech. It only lasts 45 minutes. And what a pleasure to work with the board and staff and also our aligned professional organizations. It's really make my tenure experience at board more memorable. And particularly that I enjoyed each of the debate and we arrived some of the consensus. Sometimes we hold our difference. It is just so wonderful, very educational. Thank you, every member of the board and staff. I also want to thank Harvey sincerely, people like Mark and Scott who really devoted their time trying to make the profession better and think alike how to work together and make the profession better, including either Claire from ESA. So one small announcement, I hope this will serve as a gift for everyone for Christmas.
Yay.
That is AI California and California Architects Board has formulated the MOU and it has been signed by the president of both organizations just about a week ago. So that is another indication that we really determine to make our architecture community better, make our consumer protection better. And thank you again. I enjoyed it. Everything, every board meetings. Now I'm going to have fun to look at Charles'
You can tackle him now.
and I will prolong whenever I need to, so make an amendment of meeting more difficult. So with that, thank you.